12, madam.
Item 12. Okay. Is that, I think, some instruction
Yes,
was
yes.
called for as regards prosecution sanction.
All right. That's why my instruction.
Item 12, as prayed for by Mr. A.M. Bora, Learned Senior Counsel, which is not opposed by the other side, relist. Look at that date, part heard nothing. On such and such date, for further hearing.
I beg to mention, item 41, I have taken consent of, I want detailed accommodation.
Item number?
1-4. I have taken consent of. It will come after this.
Heard Mr. S.C. Heard Mr. S.C. Biswas, Learned. Mr. Burster, you are the other
Yes,
side.
Madam.
No
Thanks,
objection. Heard Mr. S.C. Biswas, Learned Counsel for the respondent. Also heard Mr. G. Burster, Learned Counsel for the for the petitioner. As prayed for by Mr. S.C. Biswas, which is not opposed by Mr. Burster, Learned Counsel for the respondent, for the petitioner. Relist this matter after 3 weeks on a date to be fixed by the registrar.
I beg to mention item 16. So in this case, the highest legs of advocates are no longer. Yesterday, my lord, I have filed the wakalatnama. So some accommodation for preparation of the case.
Item 16, Mr.
I'm 16 and 17, my lord. Analogus. Out of the same judge.
You are in
I'm
17.
17.
All right. Any objection?
No, I'm other appeal.
No, but it's connected.
No appeal. No. Yes, no objection.
16 and 17 is together.
Actually, that is for 17.
I understood, but that's why I'm asking
Yes,
if he
correct.
has any objection because he's also he's there in the connecting appeal. Mr. Mr. S.K. Talukdar, Learned Counsel, appearing for the appellant in Criminal Appeal 58 of 2012 submits that he has been engaged
Yesterday, man.
yesterday in the appeal to represent the appellant and accordingly seek some accommodation in order to prepare the appeal. Mr. A.K. Purkashta, Learned Counsel appearing for the appellant in Criminal Appeal 131 2012 does not oppose to the said prayer. So Parashar and Mr. K.K. Parashar, Learned APP for the state academic after date deliver after 3 weeks.
After 20. Oblige.
I beg to mention, item number 10. I have taken the consent of the other.
Item number 10.
10.
Yes.
NDPS is having some personal difficulty today.
Who is having?
NDPS is having some
This
personal.
is that matter,
Yes, Amicus has been appointed.
medical bill.
Yes.
But we have already heard Mr. Deka. Let's see what the amicus has to say. Basically, the idea of keeping this matter today was to get some clarification from the point of an amicus. So let the matter reach. We'll see.
First, I beg to mention for listing of criminal petition.
I think there is a senior bench available. Please take this prayer before an appropriate bench.
May I please, Your Lordship? I beg to mention item number 30, Lordship, the supplementary list.
Yes,
Madam, may you pass over for the day, Lordship.
as prayed for by Mr.
M. Hussain.
M. Hussain, Learned Counsel for the petitioner. The matter stands adjourned for the day.
Deeply observed.
May it please your lordship. I beg to mention for listing a I lordship for suspension of sentence. Lordship. Suspension of sentence, lordship. On 10.
Why are you all not mindful when the mentioning goes on? I've just said listing prayers you mention before the appropriate bench. When there are senior benches available, then the mentioning has to be before the senior bench. There is a criminal bench available. Asan hai, rukho.
My reason worship, I beg to mention item number 23. The material kindly adjourns for the day.
23. I think you have already given advanced MS.
Actually,
MS R. Chaudhary, Learned Amicus Curie. Why are you're an amicus and why are you not prepared? It's a 12th matter.
for some personal difficulty, she won't be able to come today.
You are who?
S. Ajmi on behalf of
Ms.
Ajmi.
Counsel, please answer the query,
Am I-
the
am I-
question as asked. MS,
MS,
your name,
S. Ajmi.
Bala. MS so-and-so learned counsel submits that MSR Chaudhary learned amicus curiae for the petitioner due to personal difficulty is not available today in court and seeks for an adjournment by circulating advance adjournment slip. Prayer is not opposed. When do you want it?
Any
After vacation.
Okay.
List on such and such date. Yes.
Mayor below. Item number 19 million.
Yes.
It is the old matter million.
Yes.
Our file is missing million. So million. I can it permitted to take a photocopy of the memo.
How can you take a photocopy? You apply for a certified copy, pay the requisite fees, and you'll get everything.
Yes, million.
Uh,
Then million. I may be allowed to take
I'm
certificate.
fixing it after the reopening. Do whatever you have to do. Your name,
AM.
Mr. A. Rahman,
AM Ahmed.
A.M. Ahmed, learned counsel for the petitioner, submits that the brief has been misplaced and accordingly seeks accommodation for doing the needful. Prayer is allowed. Relist after
After Bihu million.
they believe on such and such
In the
date.
meantime, I will take certificate. Publish.
Okay. Who is appearing in 2021?
And
So have you taken the consent or not?
up to 22 million all.
You wait for your turn. Mr. Counsel, don't let the matter be called or get hold of the other lawyers who are appearing in 2021.
Yes.
Because there are also 22. These are all connected. When matters are connected,
Yes. Yes.
basic decency, courtesy, everything is appears to have been forgotten. You cannot ignore all this. Yes.
I beg to mention item
In
21,
order to cut it with you.
item number 21 and 22 of this, please.
You are in 21.
21 and 22.
What about 22?
21 and 22.
You are in 21 and 22. And 20? 20 is not here. So get all of them together. Yes.
It is a lot. If I see some problem. Here, council was just mentioned item number 12. That should have been 27.
Huh?
That should have been 27, item number 27.
Not 12.
My mistake.
27 it should have been. I said 27, huh? Not 12.
Oh, okay. Well,
The 12 is there.
there is much of that. Praise the Lordship. I beg to mention listing of a criminal petition. The item was last posted on
The Parashar. Tell him. Where do you look for? Call the list.
item number 1.
Yeah.
Yes.
Has been filed against them for not update that.
138.
Yes, ma'am. There is 46 you lost, but find that for not up.
Page.
Page 46. By which, my lord, the American case was dismissed on the ground of limitation, ma'am. There was a limitation of 19 days.
Page.
Page 46.
I'll issue notice.
Then notice maybe.
Heard, Mr.
That's not.
As not learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned APP for the state respondent number 2. This petition, this revision petition is directed against the order dated 27/11/2024, passed by the Learned Civil Judge Junior Division, cum Judicial Magistrate, first class number 4, cum Group M, Guwahati, whereby the complaint case NI being CR case number 3341 of 2018 under section 138 of the NI Act was dismissed. Issue notice returnable 3 weeks. So and so accepts for R2. In case for R1 registered post AD within 3 days. Extra copies for delivered 3 days. List after returnable date on a date to be fixed by the registrar.
May please.
Yes, 125 CRPC. Maintenance. Yes.
So the main issue is covered. The issue is that the mandatory affidavits on assets and liability were not filed.
Mhm.
Mandatory affidavit that should be filed on assets and liabilities were not filed. And the Honorable Supreme Court in such cases remanded back the matter.
But
In our
for that respondent has to be here.
uh,
Will issue notice right now on the next date.
This court, my lord, following the Supreme Court judgment.
All right, I'm issuing notice and on the next date, let them appear first.
Fine.
Your name,
Paul Oscar.
Mr.
Paul Oscar.
O. Lashkar. Heard Mr. O. Lashkar, learned counsel for the petitioner. Also, anyone respond? You're not there. Stop, huh? This criminal revision petition is directed against the judgment and order dated 1/2/2025 passed by the learned court of the Principal Judge Family Court, Kachar Silsar, in FC criminal case number 20/2022, whereby the petitioner was directed to pay a monthly maintenance of rupees 12,500 to the respondents under section 125 of CRPC. Issue notice, returnable 3 weeks. Steps by registered post AD within a period of 3 days from today. List after 3 weeks on a date to be fixed by the registry. An endeavor shall be made to dispose of this case after the appearance of the respondents.
Operation of the order may be stayed. Operation of the order may be stayed on them. Public.
It's against NBWA issue against new lawsuit. The case 20 is the order.
Page,
20.
why have you not appeared?
But I am a resident from lawsuit Bihar.
Huh?
I am a resident of Bihar. But I used to lawsuit state Bongaigaon.
You?
In respect of Bongaigaon. In respect of my job lawsuit.
Sorry, I didn't get you.
But I am a resident of Bihar lawsuit. But I used to stay at Bongaigaon lawsuit in my relating to my job lawsuit. The Samon lawsuit that was received by my wife lawsuit, admittedly my wife received. But she could not communicate with the petitioner lawsuit.
Why?
And perhaps lawsuit she has forgotten to intimate.
So casual. A court summons issued from the court. Wife forgets to inform the husband.
Well, that is absolute
Unbelievable story.
Why not your lawsuit may keep it one chance lawsuit? I will appear regularly lawsuit. If any mistake default is there, your lawsuit may pass an stand order that he will be taken into custody lawsuit. Only one opportunity.
When is the next date?
Well, next date is not given lawsuit whenever case 28 lawsuit.
But that order was from 2017. He's sleeping since 2017 now.
There's just one thing, I can issue notice, but the matter will further be dragged if I issue notice. If I dispose this by directing him to appear before the court on a particular date, until that he may not be arrested.
Yes, sir.
And after his appearance, the trial court shall pass appropriate orders in accordance with law. I think that can be done. Otherwise, I don't see any purpose being. Item number 3, disposal. Heard Mr. M. Khan, learned counsel for the petitioner, also heard. Only thing, Mr. Parashar, there is a private respondent. Can it be disposed of without the notice being issued to the private respondent? Is it?
Informal. Informal. Informal.
Format.
No prejudice with cause much. I will make here. No prejudice with cause.
That, Mr. Heard, also heard Mr. K. Parashar, Leonard APP for the state respondent number 1. This criminal revision petition is directed again at the criminal petition. This criminal petition under section 528 of the DNSS 2023 is directed against the order dated 17/5/2017. In this matter, I don't think I'm going to dispose it. I'm going to issue a notice because you see, this is a matter from 2017. I am not giving you any protection. Let the respondent come, and then this court will consider dispose of no against the order dated 17/5/2017. Another subsequent order whereby NBWA was issued against the petitioner by the court of CJM Bongaigaon in GR case number 896 of 2016. Issue notice returnable 3 weeks. So and so accepts notice on behalf of R1. Extra copies 3 days. Registered AD against R2 steps 3 days. List after 3 weeks on a date to be fixed by the registrar.
This process was made.
No, sorry. This is 2017. Now you are, this is 2025. The ground is that your wife didn't inform you. It's an unbelievable story. You want me to dismiss it? I can dismiss it with a detailed order.
Sir, shouldn't in the order that the final report is submitted before the Lanet Court of Judicial Magistrate.
You're challenging the final report.
Final report. The very first sentence proposition has been made by the IO regarding the non-finding of the petitioner and non-availability of him here also. Regarding this report,
Where is the report?
Annexer
Page,
H,
page,
Annexer page 48, Annexer H.
page
the
40.
Page 48, the relevant portion is page 50.
Yes.
From the bottom 1, 2, 3, 4, 5, 6, 7 from the 7th line from the top corner. After all efforts, the main accused of the present case, namely Riaz, the present
Where are you reading?
page 50,
50.
50.
Yes.
From 7th line, from the top. After all efforts,
Yes.
the main accused of the present case, namely Riaz, the petitioner hearing, could not be found and is unlikely to be found in future. So very much the dangerous line has been in
This is
against me,
2022.
you know.
The date is 2022.
Yes, 22. That the police has submitted this final report on before the Lanet Court on in the year 2022, whereby this honorable court has stayed the entire proceeding of the matter.
Where?
Annexure Annexure E, page 40. On 15/6/2021. There is a one historical background of the case also. The thing is that the
We will go to the background later.
yes, page 40,
Page 41 is
page 40.
yes, the order starts at 41.
43.
The FIR was challenged in this writ petition, in this criminal petition.
Standing before the honorable court and
The FIR was challenged.
FIR were challenged. And this instant FIR, wherein the final report has been submitted, has been stayed.
last bottom line, in the meantime, further proceeding of the Gorsuk police station case number 47 of the 2018 is state with a next date of fixed. But instead of submitting all the relevant documents record before the learned court, this honorable court, the IO of the case has submitted the final report before the learned court below, stating that the petitioner could not be found. Wherein the petitioner is
Where the stay, where the stay is still going on?
no, see, after moment of final report has been submitted, the court may till date not taken up the.
I'm not, sorry, I am getting confused. Now, in this order, it says further proceeding of Gorchok Police Station, so and so is stayed.
Stay,
Now, this stay is still operating, is operating.
still open,
Now, during the pendency of the stay order, they have submitted FR.
FR. Stating.
But then that is because there is already a stay.
How can you?
How can the FR be submitted when the further proceedings have been stayed? That means the authorities cannot do anything, isn't it? That is your case.
What is the case?
It is still pending.
Still pending.
And this FR was, this order is of dated
To 15/6/2021.
21 and FR
We
is,
have submitted on 39/2022.
where do I get the date?
Page 50.
Yes. And where is the reference of the GR case? The reference of the GR case, where do I get it? Because the type copy.
Uh, yes, can be on the original copy, page 51, hearing the course of case number 47 only 18, page 51. And,
Mr. Parasha, prima facie, it looks not correct. You are the complainant.
I am the accused person. I'm the wherein my the IO has stated that I am not available. So if the proceeding may be initiated before by the landed court in view of the non availability of the accused person. So the court below may take may declare me a absconder in this case. It is a what is
Okay. Your name?
it?
Heard Mr. H. Burwal, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned APP for the state respondent. This criminal petition under section 528 of BNSS is directed against the impugned final report. Final report number 459/2022 dated 30/9/2022, filed by the investigating officer in Garchuk PS case number 49/2018 under section 436 of IPC. Stop.
Only one, this is an interim order, test 41, 2621 interim order, it's a state. But subsequent what happened to this petition, we don't know.
All right, Mr. Parashar, then I'm keeping it for 5-10 minutes. You check up the
Yes, yes.
status in your mobile. You will know whether the stay is continuing or not, because since Mr. Counsel have made a submission, I have taken it on face value.
No, ma'am.
If you can show that he is not correct, then I'll dismiss it with cost. And if yes, then I'm staying it. You wait for some time, you can also find out.
Yes, yes, yes. It's a statement because
I'll take it after some time.
yes, yes.
Call them. In order to put for you.
Wait, please. My lord, in this matter, my senior Mr. Goel will be appearing. He is currently at legs at booth number 17. Not
Pass
even
over for time being.
For the time being. Keep your place.
Charge sheet quashing, Mr. Viswas,
My lord, this is an application.
and also cognizant. Oh, acquitted.
No. This is, my lord, the notice has been issued to us regarding this 294, 354, 323. And my lord, the charge sheet has been filed against us and court has taken cognizance page 45, my lord.
Page 45.
Yes, my lord.
You are challenging the
Yes, 341,
cognizance and the entire proceeding.
Yes.
Page 40.
page 41, 45.
Yes.
Three 294, 506, 114, 34. But what happened? During the flood, I am an advocate of this Karimganj Park. I, along with my father and my husband, went to a relief camp to see whether the reliefs are being properly distributed. Then my allegation has been made that we have assaulted them, we have tried to take away the relief material trucks to other place and cases. We were assaulted. We have filed a FIR, my lord. That is also
Where is
charged against
the
them.
complainant? This is an FIR?
Yes, sir.
Where is the FIR?
FIR is at page, my lord, 28, can you? 28. May I read, madam? Page 28, annexure 2. It is respectfully submitted that since 20/6/24, myself and other 4 persons of my village being affected by flood took shelter in 552 number LP school flood relief camp. Today on 22/6/24 evening at 5 p.m., the teacher of the school appeared in this camp in a truck carrying rice, pulses, and mustard oil, etc. At that time, above mentioned opposite parties appeared in the school with their associates of the tried to take away the truck to their village, to which myself and my other
But
inmates.
there are allegations.
Allegation, my lord, allegation
Cognizance
initially
is-
307 case has been registered against me.
You see,
Now, my lord,
Mr. Biswas, right now it is in a very, at a very beginning stage. Only cognizance has been taken.
yes,
You-
that's
and
why I'm
summons have
challenging
been
you.
issued.
You lordship, and call for this
You-
scan copy of the matter.
No,
Your
no,
lordship will
no,
examine
no,
it
no,
when
Mr.
kindly
Biswas,
examine it.
why should I examine at this? You appeared there. After that, if charges are framed, and then we can look into the matter.
No, my lord.
Right now, why should we interfere?
Learned court has taken the cognizance of the matter.
Cognizance has been taken and an issue summoned. You-
Cognizance has been taken out under 341, 294, 503. All you know the implication of all these sections, nothing. Threatening, 341 restraint, 291 abusing.
So, but the charges have not been framed. That stage is yet
But
to
charges
come.
to explain, I know, but
Sorry,
but
you
I've got
want
right to
notice, I'll
challenge.
give you
I've got the
notice.
right to
Otherwise,
challenge.
I don't find anything here. I can dispose it of by dismissing it also. I don't see anything. Allegations are there.
The
It's a
allegation
very
of what,
initial
madam?
stage.
Allegation, the
Mr.
FIR
Biswas, it is
and the
at the
charge sheet is
time, the
different.
above mentioned opposite party appeared in the school with the associates and tried to take away the truck to their
But that
village.
is not there.
To which myself
But the
and
charge sheet
other
is
inmates
different.
objected, then accused number 1 to trespass into our school and tried to pull down the saris of, say, Salika Begum, so and assaulted us by fist.
This lady
And-
was not there, even not in the picture.
Charge framing stage has not come, Mr. Biswas.
No, my lord, I think it is not illegal to come before your lordship under Quashing.
Sorry, issue,
Kindly issue, then in the notice may be issued, my lord.
I'm doing that. Heard Mr. S.C. Biswas, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned APP for the state respondent. This criminal petition under section 528 of BNSS 2023 is directed against, is presented for quashing of the charge sheet in connection to Karimganj PS case number 450, 450?
50, 24.
Stroke 2024 under section 294, 354, 323, 34 of IPC. And the order dated
28,
28/2024 passed in PRC case number 1990 of 2024, whereby the jurisdictional magistrate court has taken cognizance of the offense under section 341, 294, 506, 114, 34 of IPC against the petitioners and issued process against the petitioners. Now, issue notice returnable 3 weeks. So and so accepts notice for R1, extra copies within 3 days. Steps by registered post in respect of 2 within 3 days, and list after 3 weeks on a date to be fixed by the registry.
मतलब I have checked, मतलब last order मतलब 13/12/24 interim order continued.
Lordship, in that particular order, the honorable court has also directed to place all the relevant documents. Earlier order passed on several occasions to bring on the case diaries, all the records. And this honorable court also has
All right, all right. ऑर्डर तो असं ना की लिए लिखना
पता है नंबर या रिक्वेस्ट करते हैं.
issue notice returnable 3 weeks. Mr. KK Parashar and APP accepts notice on in respect of 1 extra copies within the course of the within 3 days. Registered for Deputy Commissioner of Police, you can appear 1 and 2.
Two I can, if you others by name, I
1 and 2. And in respect of 2, 3, 4, and 5, registered footsteps by registered post 80 within 3 days completed. Mr. Borwa has Mr. Borwa, counsel for the petitioner, submits that the proceeding in connection with Gorchuk Police Station case number 47/2018 has been stayed by this court in criminal petition 341 of 2021. And while the stay is while the stay is operating, the respondent authorities has submitted final report under section 173 CRPC before the magistrate court, before the jurisdictional magistrate court in respect of the said case. He accordingly submits that he accordingly submits that such action, the FR submitted is in violation of the interim order passed by this court. Apt to refer to the perusal of the FR, which is enclosed as Annexure H to the petition, it appears that the investigating officer, since after all efforts could not find the accused petitioner, he could not file the charge sheet against the petitioner, and upon such lack of sufficient evidence, FR has been submitted before the magistrate court with a prayer to accept the same. It appears that despite a clear interim order passed by this court for stay of further proceedings in Gorchuk PS case number so and so, the investigating officer continued with the investigation and has submitted the said FR. That being so, the petitioner has made out a prima facie case for grant of in support of the interim relief prayed in the petition. Accordingly, in the interim, this court is pleased to stay all consequent proceedings of Gorchuk PS case number 47/2018. No, don't say that. That is already a stay. Is pleased to stay the FR. I'll stay the FR. Isn't it? is pleased to state the, what is the number, any number is there?
459,
Is pleased to state the impugned FR number
459 oblique
459
459
oblique
20222.
2022 submitted and dated 39/2022 in Gorchuk PS case number 47 of 18 until further orders. List after 3 weeks on a date to be fixed by the registry.
One, serial number 1 and 2 I am appearing. Their mistake.
There is a
It should be 3, 4, 5 and 6.
345,
345,
345 and 6.
Notice should be issued, Malak.
I have issued.
Lost.
What did I
No,
say?
no,
There is a mistake in the
Yes.
number, Malak. Then 1,
Huh?
2, again 2,
1 second. 1, 2, তেওঁৰ কথা কৈছো না?
then 3,
1
4,
and 1 and 2 you're
Yes, yes.
accepting, and then not 2, 3,
4,
4,
5,
5 and
5 and 6.
Lost. Lost.
Correct.
lost.
Yes, Mr. Viswas?
Okay, this is a application under 528 of the PNS. Now, here, the petitioner of your lordship is an advocate, a profession. Now, what has happened in this case is that a complaint was filed by the respondent number 1 before the magistrate, judicial magistrate, Nagaon, first class judicial magistrate, Nagaon. Now, that has been annexed as Annexure A at page 28.
Page?
I'll just give the brief. That in the complaint, it has means appears from the complaint that the respondent number 1 and respondent number 2, there was a dispute, service dispute with regard to transfer from posting transfer, against which the respondent number 1 has alleged that a caveat was purportedly served upon him on behest of the respondent number 2 through the advocate counsel, the petitioner before your lordship. Now, thereafter, when the respondent number 1 filed the writ petition before this honorable court, and he searched for the complaint, the caveat had been filed or not, upon inquiry in the office, he came to know there was no such caveat lodged. And thereafter, he filed the case and his case was disposed of. Now, on the basis of this, he has alleged that the advocate concerned has committed forgery, etc., and has tarnished his reputation, etc. And the court, strangely, on the allegation that the caveat was not filed, has taken cognizance against the advocate concerned and has issued.
Where is the FI?
The order your lordship will find at page
71. That I have seen.
71.
That I have seen. Where is the complaint?
Complaint at page your 28, your lordship. It's quite strange how the trial courts also proceed, your lordship. Now, the accused number 2, your lordship, in the second column, your lordship will find the name is there, the petitioner before your lordship.
And you
Now,
are the number 2.
Yes. Now,
Who
your
is
lordship will come.
number 1?
1 is the respondent number 2. We have pro forma, we have made him a party in this.
Let's read the complaint.
Yes, if I may. Page 28, it starts, your lordship. The complainant is a citizen of India by birth and the permanent resident of the aforementioned locality, such and such. I'll skip that here. Para 2. The brief background of the case is that the complainant was initially appointed as a Gram Rojgar Sahayak on such and such on contractual basis to perform his duties under GP Secretary such and such under Block Development Officer, duty of development block. The complainant service was under the administrative control of the District Rural Development in Nagaon, and accordingly he joined his duty before the Secretary such and such on 3/9/2009. That the complainant begs to state that he was earlier transferred from this such and such Panchayat now to on 9/1/2018 by the Chief Executive Nagaon Jila Parishad. He had duly complied the state transfer order by joining in the new place of posting on 24/1/2018. Thereafter, he was again transferred to such and such on 6/10/2021. and he had honored the said transfer by duly joining his new place of posting on 7/10/20. The complainant begs to state that for the last about 13 years, he is serving his duty regularly with utmost sincerity and honesty without any service break or such as to the satisfaction of the authorities. But for the last 3 years, he is suffering from severe pipes and other ailments. It is worth to mention here that the distance between such and such to his residence is more than 25 kilometers and more than 1 hour road journey, for which he is facing extreme difficulty in traveling. Despite that, he regularly attending his office in his acute condition, which is further deteriorating his health condition. Even the doctor had strictly advised him to avoid long distance and advised him to take rest. The complainant begs to state on such acute condition, he and the accused person. Here, the accused person, he refers to the respondent number 2. That is the respondent number.
Yes, yes, I have understood.
Accused number 1. DPS officer had jointly filed an application before the Commissioner of Panchayat and Rural Development to give them mutual transfer. The complainant need transfer for such and such to this, while the accused person who was working in this wanted to join his place of posting.
Mr. Locker, you are there? Yes, sir.
That the complainant begs to state, on the basis of the said mutual petition dated such and such, the Honorable Commissioner of Panchayat and Rural Development had passed an order such and such dated 10/10/22 for transferring the complaint from such and such to this GP. And the
But there's
accused
a-
person from
The petitioner
Yes.
is the advocate who had given the caveat. And for giving the caveat,
caveat, this is and the court has taken cognizance.
what is this, Mr. Parashar?
Means how the trial courts function, I am
What is
totally.
this? Absolute no application of mine, such mechanical approach. An advocate has been,
Advocate files a caveat.
the cognizance has been taken because she has issued, she's the advocate who has given the caveat. And when this complainant received the caveat, he files the complaint against everyone, and it is service matter,
And
transfer matter.
interestingly, Your Lordship,
Paragraph 12, I went little ahead of you, Mr. Biswas. Please read paragraph 11, because there was initially two persons, they together, they wanted to do a mutual transfer. Later on, when the orders were given and the complainant went to, had gone to take charge, the other person didn't relieve him. He said, "Then you wait for a few days." And ultimately that got modified, and he was, it basically got revoked. Now, any case for that? And then read para 11, and after that revoked order, he, obviously the other person, he took, he filed a caveat, because otherwise the complainant is going to file a writ petition and get a stay. And this
Interestingly,
complaint has been filed. I am totally shocked. How cognizance has been taken. Mr. Biswas, just read loud yes, Mr. Parashar, read paragraph 11 and 12. This is how things will go. Then every lawyer sitting in this
we will be
room
under-
is going to be, for filing
and
caveats.
how we are defaming him, I don't know.
Read para 11 loud. Let everyone hear.
If I may.
Yes.
The complainant begs to state, after joining in the new place of posting by him, the Commissioner of Panchayat and Rural Development Assam had again passed an order dated such and such by modifying his earlier order and staying the respective transfer of the complainant and the accused person under such and such, and gave direction to join in his early place of posting. Once the transfer order was executed and both the complainant and the accused person had joined their respective place, there was no any valid reason to modify the earlier order such and such. Number 12, the complainant begs to state that subsequently he filed a representation before the Commissioner of Panchayat and Rural Development on such and such to prevail the order dated 10/10/22. The complainant was utterly shocked when he received a copy of the caveat to registered post from the peon of the postal department, which was sent from the accused person through his engaged counsel, namely such and such, who is the petitioner,
Yes.
Your Lordship,
Petitioner.
on 14/11, 2022. Thereafter, finding no other Alternative, the complainant had approached before this honorable court on such and such, and the same was disposed of on 25/11/22 by giving a direction to the commissioner such and such to consider the representation by passing a speaking order within a period of month of receipt of this. The copy of the caveat is this. The para 13, your lordship, page 35. The complainant begs to state that it is mandatory to verify whether a caveat has been filed against this and it would be challenged by the petitioner before a writ petition in the Honorable High Court. So the complainant through his Mohuri checked about the existence and found that no such caveat exists. In the accused person, the copy of
And I'm staying it.
Otherwise, we are not the party, we are not the private.
these are private disputes, but the thing is, your lordship,
Yes, yes, madam.
your lord, how the trial courts function in such a manner.
Heard Mr. A. Biswas, learned counsel for the petitioner. This is an application, this criminal petition is presented under section 528 of the BNSS 2023. Seeking quashing of the complaint case being CR case number 165/2023. Pending in the Court of Judicial Magistrate First Class, Nagaon, Assam. So far, it relates to
The petitioner,
the petitioner,
the accused number 2.
petitioner I, Srimati Mamuni Das. And the order dated 21/7/2023 passed by the Judicial Magistrate First Class, Nagaon, Assam, by which cognizance has been taken under section 420, 463, 464, 469, 471, 500, 506 IPC against the petitioner. Stop. Issue notice returnable 3 weeks. Steps by registered post AD within a period of 3 days from today. It appears that the respondents
Number 1.
number 1 has filed the complaint before the Court of Chief Judicial Magistrate, Nagaon, against the petitioner and the respondent number 2. Alleging inter alia as hereunder. Paragraph, page 4 A to A, page 4 of our DPL. Yeah, A to A. Perusal of the complaint, it appears that the allegation primarily against the petitioner is that she had lodged a caveat in connection to the service dispute which has arisen between the complainant and the respondent number 2.
It is allegedly because we are
Allegedly. Right, reason, Stop. It appears that the magistrate court by order dated what is the order date?
21/12.
So and so.
Sorry, 21/7/23.
Took cognizance under section 420, 463, 464, 466, 469, 471, 500, 506 IPC against the accused, against the petitioner, along with petitioner and the respondent number 2. Prima facie, it appears that no criminal offense appears to be made out on the basis of the allegations made in the complaint. against the petitioner. And full stop. Accordingly, the order dated
21. 21/7/23. Because it starts from page 70.
Yes, yes.
continuation.
No, I'm just taking it from your prayer portion. Order dated 21/7/2023, passed by the Learned Court of the Judicial Magistrate First Class Nagaon in CR case number 165/2023. To the extent, the same relates to the petitioner, along with the complaint case number CR. No. I think that should be
That should be
sufficient.
enough. Yeah.
So far as don't say to the extent, so far as it relates to the petitioner, is state. The only thing nowadays, a date is, it is better to stay till the returnable date because these are criminal proceedings. Until further,
I think it is fixed on 10th. I think.
is stayed till the next date.
Obliged.
List on after when a returnable date to 3 weeks, list after 3 weeks and a date to be fixed by the registrar.
Obliged.
Yes, Mr. Goel.
Hello, the challenge before your lordship is registration of FIR and charges, subsequent charging. The basic allegation in the FIR is that I have stolen
Hmm.
photographs from Facebook account. I have
Photographs
stolen
from Facebook account,
Facebook account,
cybercrime,
my lord.
cybercrime.
This is cyber crime there. My lord, Facebook account is social account. In fact, what has happened, my lord, the petitioner is now working as a constable in Assam. Before appointment as constable, he was a newspaper hawker, your lordship. In 2008, he appeared in constable recruitment exam and he did not succeed. Subsequently, he filed writ petition before this honorable court. Writ petition also dismissed because according to the authority, I fall under the category of general category. Subsequently, my lord, it has come to that the authority.
You are
has-
challenging what? The FR, the
FIR
FIR.
and charge sheet. Why I am
Let-
submitting
let-
this, my lord?
Let's see the allegation in the FIR.
Because of the counter.
Because right now, only for the interim, isn't it?
My lord.
Let's see the FIR,
FIR,
whether
my
the
lord, will
allegation
be at page
makes out
30.
a prima facie case or not.
330, my lord.
Yeah.
Informant, he was sub-inspector in SI or in Assam Police, my lord. However, without taking my consent, has illegally stolen my photograph from my Facebook account. And thereafter hacked my Facebook account and thereafter manipulated the said account, taking false entry showing Santosh Chaudhary checked in Bangkok, Thailand, so and so. That matter is sub judice, my lord. For mentioning that I was very much in Guwahati serving as government of Assam in the capacity of assistant sub-inspector of police with additional DGP Vigilance, Assam, in the office of Director of Anti-Vigilance Corruption. It is pertinent to mention here that also was working day and I was very much in the official duty in the Guwahati. I have recently learned that despite the investigation being closed, after thorough investigation which lasted more than 1 year, the accused all of a sudden without my will, reasons appeared before the special judge, Assam, and filed a petition fabricating false evidence against me, misusing my Facebook profile, which he has stolen illegally against my knowledge, and thereby fabricated false evidence against me, and I am including evidence of my
Allegations are serious. I
My lord.
cannot stay this.
why I am saying, my lord, why this type of allegation has been given.
Mr. Goel, you are aware of the limitation that the sport has while exercising
In fact,
quashing
special judge has
jurisdiction.
taken cognizance.
And you see, this is a notice has not been gone. Let notice go.
My lord, what
I will keep your interim
my
open.
lord, my lord. Only
I-
one thing
You want me to consider the interim today, then
no,
I'm
my lord,
telling
I am
you
not,
that I'm
only I want
rejecting
to,
it.
my lord, raise one fact.
Not now.
My lord.
Factual aspect, this court cannot go into. You know the settled law. Heard Mr. A. Goel, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned APP for the state respondents. This criminal petition is presented under section 528 of the BNSS for setting aside and quashing The FIR registered as Panbajar PS case number 251 of 2019, registered under sections 379, 120B, 192, 420, 468, 500 of the IPC, 1860, read with section 65 and 72 of IT Act 2000. Inter alia, you do it, huh? Inter alia. And charge sheet bearing charge sheet number 6619 dated 36/2019. And order dated 9/7/2019 passed by the learned judicial magistrate taking cognizance against the petitioner. Stop. Issue notice, returnable 3 weeks. Mr. Locker accepts notice. R1, extra copies within 3 days. R2, steps by registered post AD within 3 days. List after 3 weeks on a date to be fixed by the registry. The prayer for interim relief shall be considered after the
Service upon it.
after the service of responding numbers, after due service of the upon the respondents.
Pure.
Appeal against conviction also. But the appeal has to be admitted and nobody has to go on the appeal as well as in the IA.
Mr. De Gogoi,
R for
R. Bora. Heard Mr. This is Poxo. Heard Mr. R. Bora. Before admission, the notice has to go or admit and
admitted and as well as.
For bail or to that.
that is obvious, but for the admission, I think I can admit it. Is there an IA also?
I is also there.
So I'll issue it together.
That's it.
The criminal appeal and the IA, you make it together. You heard Mr. R. Bora, learned counsel for the appellant, also heard Mr. P.S. Locker, learned APP for the state respondents. This appeal is presented, this criminal appeal is presented against the judgment dated 21/12/2024 passed by the learned special judge Poxo Karvienglong Difu in Poxo case number 07/2013, whereby appellants were convicted under section 6 of the Poxo Act. Inter alia units, yeah. Admit, issue notice, returnable, admit, and then use him notice. Mr. So-and-so accepts notice on behalf of respondent number 1. Extra copies within 3 days. Let notice in respect of respondent number 2. Let steps for notice in respect of respondent number 2, I informant, be taken to the be submitted before the registry of this court so as to enable the registry of this court to forward the same to the jurisdictional police station in accordance with the directions passed in Deepak Nayak versus so-and-so in criminal appeal so-and-so. List after 3 weeks on a date to be fixed by the registry.
Actually, can you call for the LCR? LCR has to be called for.
We will see that first that the
Since the appeal has been admitted, the LCR has to be called, otherwise the lordship won't have any opportunity.
that will come later. But we can call the
Yes, yes, lordship, that is the procedure.
let the TCR be called for.
Right.
May I tell you? This is the appeal against the judgment of conviction and sentence.
Appeal against conviction,
Lordship, 2 years imprisonment.
363 and 34.
Lordship, 2 years imprisonment. Lordship, there is lordship, whatever lordship, no medical was conducted, lordship, age was not proved, lordship, and lordship,
Right, I'm issuing it, I'm admitting it, but I, after receipt of LCR, TCR,
2 years was.
The remaining DBS,
2 years was.
there may be allowed.
Years was 10 passes.
AMS, sorry.
during the trial where you
Lordship, now they are allowed to remain in bail. Lordship.
previous bail. So during trial, you were on bail.
Lord.
First, you take the criminal appeal, huh? Heard Mr.
AMS.
AMS Majumdar, learned counsel for the appellant, also heard Mr. PS Locker, learned APP for the state respondent. This appeal, this territory appeal, criminal appeal, is preferred against the judgment and order dated 30/1/2025, passed by the learned session judge Kachar, Silchar in session case number 19/2020, whereby the appellants were convicted under section 363/34 of IPC and subsequent order dated 1/2/2025, whereby the appellants were sentenced to undergo rigorous imprisonment for a period of 2 years and a fine of rupees 25,000 each. In default of payment of fine, to undergo simple imprisonment for 1 month. Stop. Admit, issue notice, returnable 4 weeks. Mr. So-and-so accepts notice on behalf of respondent number 1, extra copies within 3 days. Registered post AD in respect of R2 within 3 days. List after 4 weeks on a date to be fixed by the registry. I now take the I
Lordship, LCR may be called.
of call for TCR, huh? Through registry. I is for disposal, huh? On the top, it will be same and heard same, and then instead of appeal, it will become now this application is filed under section 430 of ENSS 2023, seeking suspension of. The rest will be same. Okay. And all seeking suspension of so-and-so, and at the end you add, and for allowing the applicants to remain in previous bail in the previous bail. Full stop. Mr. So-and-so Majumdar, learned counsel for the petition, submits that the petition applicants were on bail during the trial and has attended on all dates as fixed by the trial court. And accordingly prays that prays for a direction to remain on the previous bail pending adjudication of the instant appeal. Stop. Mr. Locker APP does not oppose the said prayer. Peruse the judgment and order dated so and so. It appears that the applicant has made out a prima facie case in support of the interim, in support of the prayer made in this interlocutory application. Accordingly, this court directs suspension of the operation of the judgment and order dated 30/1/2025 and subsequent order on sentence dated. Without suspending, I can simply allow him to be on previous bail. That can be also done. Accordingly, this court disposes of this interlocutory application in the interest of justice by allowing the applicants to remain in previous bail in the interest of previous bail, pending adjudication of the instant criminal petition appeal. Accordingly, the IA states.
Right.
Mr. Manan,
Wait, please, your lordship. This is a application, the 483 of BNSS, your lordship. The section is 20B2C of NDPS,
20.
20B2C. Your lordship, the 22.225 kgs of ganja was recovered with a drum. This is the matter earlier. Your lordship has rejected this matter, so you have to come back to your lordship.
The
Yes.
second petition.
This is the second.
Where is the earlier rejection order?
That is, your lordship. Yeah, I copied it. I have this. It's not the next. We have mentioned it.
And
Copy.
copy is there.
I have given a copy. File is not registered.
Huh?
Copy is not registered.
No, because
So that rejected.
last time also you had taken time to,
No,
for
they
a
have
day to
taken
go
time.
to the scan copy. Have you
I
gone
can't-
through
I
or not?
can't-
Huh?
I can't do the copy. I'll say it also.
You want it right now?
Alright.
What is the change circumstances?
Lordship, there are 4 grounds that I'm bringing, which were not there earlier. And these are, at least 3 of them are grounds which is violating the Article 21 and 22 of the Constitution. Technically, these are the grounds on which
But Mr. Manan,
Yes.
I will hear you. I'm sure you're going to cite that decision also, but this, we are dealing with an NDPS case.
Yes.
The trial is not completed, correct? Now, these are, if there is any violation of the procedures, these are factual aspects. This has to be proved during trial for consideration of grant, not grant of bail, since this is commercial quantity. The rigors are under section 37. So under section 37, this court has to only see whether he is guilty or not
Yes,
guilty.
that is why.
Isn't it? Now,
Lordship
this
is
court,
absolutely correct.
this court has already have gone through all this and rejected it. Now,
I don't
second
know
time you
whether-
have come.
Whether those grounds were taken up or not, because those are not reflected in the order.
Correct, but be that as it may, you see, this is not a review.
Obviously,
This is not a appeal. This is second time. Now,
Yes.
if you come before this court second time, then you must show that there has been some change in circumstances.
exactly.
is the
That
only-
also I will. That
Huh,
also I
if there is some change in the circumstances, then this court will
Yes.
consider, but not about grounds not taken, because this is not a review.
that's
Again,
not
that,
a review, but the
suppose
question
these
is,
grounds have not been taken and there is a
many?
grievance, then this matter can be taken
So normally what
to
happens,
the
your lordship, in a bail,
appellate court, to the to Supreme Court if need be, but second bail application for arguing grounds which were available at that time. Sorry, Mr. Manan, this court
That is
Will
what
not
the
keep
lordship-
that, but anyway, just 1 second. I am indicating my mind to you so
Yeah,
that
I understand,
uh,
your lordship is correct. But certain things, your lordship, which were not at that point of time. That is what I am trying to point out, because at that time the witnesses were not there. Now the witnesses have come, and I am trying to point out two things on the basis of that.
all
As
right.
well as one thing which is very important, your lordship, the basis of the whole case. Basis of the whole case was the recovery of 22 kg of ganja along with the drum. Now, your lordship, two things. The drum is a drum, it is written as a drum, which is on which there is the ganja. It is a water drum where the ganja was available, and along with the drum, it was weighted. Anyway, that was weighted, and it comes to 22.2. Now, your lordship, the whole thing will change if the drum and the ganja was separated and weighted, because I think the
Trial
drum.
is not over.
I'm just saying that, lordship, kindly take a few moments to listen. I'll bring lordship.
How many witnesses
Lordship
have been
accepting it,
examined?
rejecting it.
How many witnesses have been examined? Huh?
As of date, your lordship, six, seven,
Out of?
19.
Out of 19
Nine.
witness, only 7.
Seven. That is why I have another ground that I'll come to that. Here, what has happened? If your lordship, the weight of the drum, we don't know what is the weight of the drum, we don't know what is the weight of the narcotic substance. So if the weight of the drum is more than 2 kgs, which is obviously there, it will be more than 5 to 10 kgs, I think. Then the section itself will be different because it will be less than commercial quantity. Commercial quantity is 20 kgs and it is just 22.5 along with the drum and other like ropes and other things. So that is the very good question. The whole section will change if it is below the commercial quantity. Number one, that is one point which I was trying to point out. Second point, your lordship, here the second part comes is long incarceration. Why I'm saying that? Because your lordship, there's 19 witnesses, 6 or 7 witnesses have taken place. And on the other side, the witnesses which have already been considered, the evidences does not implicate the petitioner at all. And second point, the procedure which was prescribed under the rules have not been followed at all as per the evidence of the
For
witness.
search and seizure or for procedures for?
Procedure for seizure and your lordship, search, seizure, and there is a rule. That rule is
42.
2022 rule. That is
42 or
absolutely
22?
absolutely violation of that. Third is that the most important part where the Honorable Supreme Court, I'll also cite the judgment. The Supreme Court says that there has to be a notice by the police while arresting an accused, and in the notice the grounds have to be given clearly. That specifically has not been given, which is violative of Article 21 and 20. In fact, with regard to the it is already 2 years in custody. So therefore, I have another additional prayer that there is also long incarceration when 37 will not apply.
Mr.
When
Kannan, I'll take
these
this
two cases,
matter,
37 will
I'll
not,
take this matter tomorrow, but you give me a write-up and
with regard to the grounds.
grounds along with the
The citations.
decision that you
I
want.
can
to
give
give.
the copies of the judgments.
You included it in that write-up. Tomorrow.
Your lordship,
Try to
judgment
get
also
hold
one
of
judgment.
Justice Chandrachud's judgment where where it is laid down that these are the grounds of procedural violations are factual aspects. These are to be gone at the trial.
The entire substance has to be counted along with the.
Keep that. Ashwin, relist tomorrow?
Lordship. Yeah.
Day after?
Day after, your lordship, let me
Day after.
draft that. Much of it.
Yes, Mr. Sharma. Come this side, Mr. Sharma.
Before my dialogue starts, my lord, may I submit, I have completed my argument, my lord. I
Yes.
have given the citation. And under only one citation I want to cite, my lord. That is 1995 to 3 SCC 42. Paragraph 20, I have given it.
Lisa. On what point, Ms. Bhattacharya?
That medical facility And right to health is a fundamental right of a person from their point of view.
This is in relation to what service?
It is my not consumer education and research center. And then whatever maybe my concept is the concept laid down by the.
This council, that is where it is important. Because that is a different thing. Now you're before it is the plantation.
Plantation.
And this is not a writ petition which you have filed. This is under the,
I am respondent.
correct, and you see, it's a reference case. It's a reference
Because
case.
the question of filing my.
Anyway,
because
you have
award is
concluded
my-
your arguments. So
Award is my favor, madam.
I'm not saying about that. Had it been a case where you have come by way of a writ petition and you'd have raised all these grounds in a different context, yes, of course, but this is a reference case. It originated from a reference case. Anyway, you take your seat. Let us hear the amicus.
Yes, madam. And in 1996, 2SCC minor, that is one decision I have cited minor, 336.
No, today you have given 95-3 SSC.
1995, 3SCC.
42.
42, paragraph 12.
All right.
Ratio will be the same minor, that is my submission.
Decisions of the apex court are contextual. It has to
Then
be.
you lordship will
It has to be, that is the only thing has to be understood. Otherwise, one line ratio, and if we start applying that in all cases, irrespective of whatever the facts and circumstances of that case be, then it would be very dangerous, Ms. Bhattacharya. Anyway, you have made your argument. This court will consider it. Just please ask your junior to just give a list of the cases which you have cited, because otherwise it will be confusing. There are too many case laws that have been cited. The other day also you had cited 2-3 cases, so just give that list. Your junior can give the list to the bench clerk. Yes, Mr. Sharma.
Your Lordship, I will not go through the facts as facts are already, Lordship has heard it meant. I will try to based on law and connect the law with the facts.
Correct.
And I will argue under 4 headings. The first is whether the reference itself is bad. Because it is beyond what is permissible by law. In that context, whether the reference is good or bad, that would be my first argument. Second would be, if the award is contrary to a statutory provision or established industrial law, then can it be sustained or it be set aside? Third is whether the reference is on humanitarian ground. And the labor court on deciding the issue, taking statutory provision, whether it is transfers beyond what is been referred, and whether the labor court can do so or and has jurisdiction to decide the issue. And fourth and fifth, whether this honorable court would mold the relief and issue direction, that is, have the power to give mandamus, and also this honorable court's tertiary jurisdiction while examining a labor court under 226.
Right.
Regarding the first issue, if the reference is good or bad, here the reference itself says on humanitarian ground, meaning thereby the labor consultation officer has not pointed out any right that has been violated or any right that the workman has.
Who has not pointed out?
The consultation officer of the government of Assam, while referring the dispute to the labor court, has not pointed out that there is a certain right in favor of the workman. And
In other words, the factum that there is no provision of law is presumed.
presume. And by doing so, by referring a dispute where there is no right in favor of the workman and the corresponding failure of the management either to exercise the right in favor or failure, there is no reference in the reference itself. So whether the hypothetical reference can be referred for adjudication by the labor.
In other words, it looks like it is equity. So whether the labor court
Has,
has equitable power or not.
in that regard, I would like to place a judgment of the Honorable Supreme Court.
There is one decision in this where the real dispute was, but that is on a different.
Because if the labor code also cannot go beyond the reference, because they have taken the help of section 10, that is my third point. May I read the
Yes.
judgment, this one? The short question of law which was to be decided in the present appeal is whether dispute raised by the employees of a general insurance company against the employer for payment of bonus in a particular year can be referred for adjudication by industrial tribunal under section 10(1) of the Industrial Dispute Act 1957. What has happened if I give a short background to this case was that the act prohibits any remuneration to the workmen or the employees of the insurance company where the remuneration takes the form of bonus. But the reference was whether they are entitled for bonus, which is not permitted under law. A preliminary objection was raised before the tribunal. The reference still is bad in law because there is no right violated or there cannot be any relief can be granted to the work. So the tribunal upheld that objection saying that reference is bad. It went to the Supreme Court. Supreme Court also held that reference is bad in that comment. The workmen 1961 AIR 19 SC 853. The workmen of the Hercules Insurance Company Limited are the appellants and the insurance company is the respondent before us. On April 11, 1950, the central government referred the application claim for bonus for the years 1954 and 1955 for adjudication of the industrial tribunal. And this reference has been made under section 10. Before the tribunal, the respondent urged a preliminary objection against the validity of the reference itself. Its case was that the payment of bonus by insurance company is conditioned entirely by the relevant provision of the Insurance Act, and that the said provision did not justify the reference of a dispute in that behalf for adjudication by any industrial tribunal. This preliminary objection was based on the provisions of section 31A(1) and proviso 7 of the Insurance Act. It was urged by the respondent that having regard to the limitation imposed on the general insurance company by section 40C of the Insurance Act, the claim for bonus made by appellants could not be sustained. The tribunal has upheld the preliminary objection raised by the respondent and held the reference invalid. Can we then go to paragraph 3?
Yes.
The preliminary objections raised by the respondent is founded on the relevant provisions of section 31A of the Insurance Act. And so we must now turn to the said provisions. Section 31A(1)(c) of the Act provides inter alia that the notwithstanding anything the contrary contained in Indians Company Act 1913 or in the Articles of Association of the Insurer, if a company on any contract or agreement, no insurer shall, after the expiry of 1 year from the commencement of the Insurance Amendment Act 1950, be directed or managed by or employ as a manager or officer or in any capacity, any person whose remuneration or any part thereof takes the form of commission of or bonus in respect of the general insurance business of the insurer. Thus, looking at section 31A(1)(c) by itself, without the proviso, the position is absolutely clear. The respondent cannot be directed to employ the appellants in any capacity so as to include in their remuneration a liability to pay bonus in respect of the general insurance business of the respondent. Bonuses under the Industrial Dispute Act is not part of the wages, but a right to claim bonuses which has been universally recognized by the industrial adjudication in cases of employment falling under the said act has now attained the status of a legal right. Bonus can be claimed as a matter of right provided of course by the application of the full bench formula. It is shown that for the relevant year, the employer has sufficient available surplus in hand. Therefore, a claim for bonus made by the appellants in the present proceeding is a claim in respect of the general insurance business of the respondent, and if allowed, it would add to the remuneration payable to them. In other words, bonus claimed by the appellants, if awarded, would, for the purpose of section 31A(1)(c), be a part of the remuneration, and that is precisely what is prohibited by the state petition.
Then paragraph 5. It is however under the proviso may, because they try to distinguish in paragraph 4, the other side tries to distinguish, it is the proviso also makes a provision for payment of bonus. The Supreme Court negated that if it is barred under the law, there cannot be any reference to decide that issue. It cannot be beyond what is permitted under the law. There has to be a violation under law or a reference to be. Paragraph 5. It is however urged the proviso 7 merely enables the central government to prescribe the maximum. It does not take away the central government authority to refer an industrial dispute in respect of bonus for adjudication under Section 10 of the Industrial Dispute Act. In this contention, it is urged by Mr. So-and-so that in some cases, the central government may take the view that financial position of the insurer justifies the payment of bonus, but the quantum may be better left to the industrial family. In such cases, the central government should have the authority to make references. Similarly, it is urged that the central government may decide that within the maximum prescribed by it, the bonus should be paid by the insurer. But the insurer may not comply with the central government decision. And in that case, the only way to make the central government's decisions effective is to refer the matter to adjudication and enable the employees to obtain an award which can be executed. That is why the appellants contended that the enabling provisions contained in provision 7 should not be constituted a bar against the central government's power to act under Section 10(1) of the Industrial Dispute Act. We are not impressed by this argument. In our opinion, the policy of the relevant clause of the proviso is absolutely clear. Payment of bonus by the insurer was intended by the legislature to be conditioned by the proviso contained in the said clause. And we feel no doubt for difficulty in reaching the conclusion that the intervention of the industrial tribunal was intended to be excluded and the matter was intended to keep within the discretion of the central government. Then as the argument for the government. So last, the lordship may see. In the absence of, down below, same paragraph. In the absence of the said provision, no bonus could have been claimed by the insurance employee. And so the effect of the said provision must be to
Only
limit
thing
the,
here, there was a prohibition.
yes,
Where did you write in the, where is it in the absence?
in the absence,
Paragraph 5,
paragraph 6 itself,
which,
in the absence of the said provisions, no bonus could have been claimed by the insurance employee. And so the effect of the said provision must be to limit the said right to the conditions prescribed by it. That is why we think that the industrial tribunal was right in coming to the conclusion that the reference made by the central government is invalid. So what I am going to lordship is that there has to be a right in favor of the worker. And there has to be a corresponding violations of the right or failure to protect that right by the management. If there is no right flowing in favor of the workman, which has been violated, there cannot be any reference. The law should give some right to the worker. So what is prescribed by law, if there is a violation of that prescription, then only a reference can be made in respect of that violation. Or for that,
but if we have to tell that, then we may be narrowing down the scope of reference. In other words, are you having anything to show that the labor court in a reference case does not exercise an equitable jurisdiction? You see, because
yes,
ultimately,
that I will show.
that if you show,
That
then
I
of
will show.
course, because you are right, that there has to be a right, a corresponding duty, obligation. Failure of not performing will give a, it will, it makes it not justified in not doing it, correct? That could be one situation. But suppose there is no right. Suppose we don't find any right. In fact, reading of the reference indicates also that the respondent authority has presumed that there is no right, because the reference doesn't say that in violation of so and so act or rules. It says on humanitarian ground, not on statutory ground, correct? Now, whether the labor could have grants a relief when it is not provided under the act.
That is my second point.
So that would be important.
That's
But if we read the award of the labor code in the present case, it appears that they have not
Gone to
considered the
humanitarian.
humanitarian ground
they've
aspect.
gone to the statutory.
They
right.
have gone into the statute and have said that this under the statute, this is what is to be done.
Right.
Anyway, 5 minutes, I'll
Yes.
come back. Just one thing. One thing. Yes.
What I'm trying to impress upon your lordship is that any reference, if it is beyond what is prescribed by law, is valid. Ultimately, the conclusion of this decision of the Honorable Supreme Court is to that effect. Yes, no doubt there is a specific provision saying bonuses which amounts to remuneration should not be given to employees. So there cannot be any reference to it. Meaning thereby, otherwise, if you read in the other context, law prescribes something, we cannot read into the law and give more than what is being given under the law. We cannot read it. So meaning thereby it is limited to those rights. We cannot read beyond that. Otherwise, it would amount to giving more than what is prescribed under the law. The first submission is to that effect. So
To just react to that submission, Pierre, you see, this is not beneficial legislation.
Yes.
That is why to
that is
restrict the scope of reference in this manner. Of course, you are yet to open all your cards, but there is some doubt going on in the mind. Anyway,
beneficial, I will show you also beneficial legislation also has to be interpreted, keeping in mind what the law says. It cannot be extended beyond that. And the second issue is now what I read before lordship is connected with the first. An award which is contrary to the statute or the industrial law cannot be enforced.
actually, you see here, let us be clear in one thing. You cannot say that the award is contrary to the statute because the statute does not provide it only. The statute provides medical setup and all that. Nowhere cancer treatment is given, right? Now, what the labor code has given is something more. They have in fact, they interpreted the act to mean that even this facility has to be given. Correct? Or in other words, they have inferred that it is included. That reading of the act does not, I don't think, indicates about cancer treatment.
Yes.
Now, if we leave that aside, then comes the reference which talks on humanitarian ground. Therefore, I'm asking you whether an equitable jurisdiction is there,
That is
whether the government also can make a reference in that manner.
my humble submission is no.
So you show me that.
Yes, because there won't be any equitable, there's no decision as such whether the labor code has equitable jurisdiction as such. But we have to, I will show you a judgment now, even reading the first judgment and the second judgment, which is relied on this constitutional judgment, saying, like your lordship has just now put forward, it act is silent, meaning thereby it is not that it is permissible. The other way of looking at this, it is not allowed or permissible. There is no casting duty upon the management to do that.
That is true.
Right.
That
When
is true.
that is absent, whether labor code can enforce or give direction to the management to do that, my humble submission is no. So there is no equitable, though there's equitable jurisdiction in the labor code, because he cannot go beyond what is provided under the law. That's it. Because he cannot give anything that is beyond the law. Otherwise, that award itself would be illegal. Meaning thereby, there is no equitable jurisdiction. The labor code does not have any equitable jurisdiction, like the Honorable High Court under 226. But here, the Honorable High Court is not exercising 226. I will just place a judgment.
Yes, yes. Before that, that's the dispute at concern. But Palang. Conduct, yeah, very good. We should have kept that book here. We will come to that decision. Reference power of government is section
10.
Now conciliation is 7.
Yes.
I think. That's it, 12.
Duties of conciliation officer. Where any industrial dispute exists or is apprehended, the conciliation officer may, or whether dispute relates to a public utility service and a notice under section 22 has been given, shall hold the conciliation proceeding in the prescribed manner. The conciliation officer shall, for the purpose of bringing about a settlement of dispute without delay, investigate the dispute and all matters affecting the merits and right settlement thereof, and may do all such things as he thinks fit for the purpose of inducing the parties to come to a fair and amicable settlement of the dispute. If a settlement of the dispute or of any of the matters in dispute is arrived at in the course of the conciliation proceeding, the conciliation officer shall send a report thereof to the appropriate government, together with a memorandum of the settlement.
Key
signed-
industrial dispute is defined,
Yes.
section
2K.
2K. It can be any dispute or difference between
Yes.
employers and employees, or between employers and workmen, or between so and so, which is connected with the employment or not. So it is quite broad, the definition.
But for the terms of employment or with the conditions of the. So we'll have to see that a dispute can be raised frivolously also. Whether there is a genuine dispute, we have to see to that.
But
Because
that of course, once the reference is made, thereafter it would be the labor code who has
to
to
decide whether the reference is valid or not. Because if a award can be given in favor of the workman, then that reference is bad because this is a reference in hypothetical scenario,
Okay,
not for the enforcement of any right under the statute.
okay.
Your lordship will see this is also a three-bench judgment, 1999, 4 SCC, 697,
Yes,
1999, 4 SCC, 697. Lordship will come to paragraph 5.
yes.
The short question arising for decision in this appeal is whether an award made under section 10A of the Industrial Dispute Act can be given effect to if it is inconsistent with the statutory provision governing the service condition of the employees. In New Manakshop, so and so versus Textile Labor Association, the Constitution bench is held, paragraph 5. 697. It is open to an industrial court.
1 second. It took over for. Sorry. Chamber will be taken over. However, there will be a kind of. Yes,
It is
they have
open-
actually misplaced that labor plantation book which I was referring in this case. Because they send the file, the section. I had underlined everything in that, and it becomes very difficult if that book is not there. Generally, I keep it inside the chamber, but since I don't have a allotted chamber here, probably somewhere it has been misplaced.
Library.
No, but that would be a different one. Day he'll check. It is not there in the library because anyway, he's trying. Yes,
It is open to an industrial court in an appropriate
case to impose new obligation on the parties before it or modify contracts in the interest of industrial peace or give awards which may have effect of extending an agreement or making new one. But this power is conditioned by the subject matter with which it is dealing and also by the existing industrial law. And it would not be open to it while dealing with a particular matter before it to overlook the industrial law relating to the matter as laid down by the legislature or by the Supreme Court. Thereafter, it went on to consider the other judgments in Marina Hotel versus Workmen. The award of the industrial tribunal holding entitlement to 15 days casual cum sickness leave was held to be illegal, being contrary to the provisions of Section 22 of the Delhi Shops and Establishment Act, which contain a preemptory directions of the legislature for leave not extending 12 days only being allowed. This decision in Dalmia Cement versus Work, which is the same effect, was followed. So is the view taken by this court in Surat. In Hindustan Times Limited versus Workmen, also the industrial tribunal fixing the period of sick leave at 15 days and permitting accumulations contrary to the provisions of the Delhi Shops and Establishment Act 1954 was held to have acted illegally. The Constitution bans, so this is a case I just relied on. The Constitution bans in State Bank of India versus Workmen and the three-bench judge in Workmen versus Hercules Insurance Company Limited have held that any reference by way of an industrial dispute seeking an award of bonus beyond the limits prescribed by law was incompetent. Next, paragraph 10 is the conclusion. It is thus clear that an award under the Industrial Dispute Act cannot be inconsistent with the law laid down by the legislature or by the Supreme Court, and if it does so, it is illegal and cannot be enforced. So, reading this judgment and the previous one, which the law does not provide, the labor code cannot give. And if cannot give a reference to reference relating to the subject matter which the labor code cannot give, reference is bad. And if an award is given in respect of that reference, that is also bad. So, in my humble submission, labor code does not have equitable jurisdiction. It's, though it's right, flows from the reference has to be a valid reference, and it has to stick to the reference. And while deciding that reference, it is bound by the law of this country, or laid down by the legislature. It cannot go beyond. That is my humble.
You have a copy of the labor plantation rule?
Yes.
Just read those, what were those hospitals and what was that mandatory duty? But that is, if I've understood your submissions correctly, Mr. Sharma,
Yeah.
what you are trying to impress upon before this court is that if in a particular rule, the services are provided, not providing those service, then it is imperative for the management to provide those services. That is the obligation. Failure of providing those services would make the decision of the management bad. Correct? However, if a particular service is not provided there, then the labor code cannot hold the management liable for providing that service because it is not provided under the industrial law. This is what you're trying to submit.
And if Lordship sees the kind of services that are to be provided under the general hospital, not the group hospital, the general hospital, it's very basic. And there may be situation where arm may be cut while functioning some machines. Then that arm there cannot be amputations or medical treatment regarding those kinds of injuries. These are very basic preliminary where they get first aid or to midwife. Those are, so while reading those services, one has to keep in mind the services that are provided in the law. It cannot extend for treatment to cancer, which is a very specialized treatment. In fact, in whole Assam, there is one. Now, TMC has another wing. How can a small garden which is less than 500 can expect to have a super specialty cancer treatment? And the reimbursement also, It's a practice, which I'll come to later, whether a mandamus can be issued for following a practice.
But the labor code didn't issue a mandamus.
No, no, labor code did. No, now, your lordship is also thinking of if at all more the relief.
Yes,
So anyway, now the third point, these 2 points,
yes.
the third point is, in any event, the references on humanitarian ground. Now, whether the labor code could have interpreted statutory provision and give relief on that. In my humble opinion, no, it has to stick to the reference because its jurisdiction is only to that aspect. If it transfers beyond that jurisdiction, they have committed error of jurisdiction. They have decided without jurisdiction. So that's why the award is denied. They should have confined their jurisdiction. In that regard, I'll just submit another judgment.
Only 50%.
5 is.
Yes,
Because here the reference was not whether the termination of service of employee was bad because in his place another person was given. So whether it violates section 25H, it was limited to that. The labor code came to a finding that there is no violation of 25H, but it gave direction for reinstatement of the terminated employee, saying that there is no record of service being kept. Labor code as well as the when it went to the apex code, it decided they could not have decided the ancillary. They should have restricted the finding only to the effect whether the termination was bad in terms of 25. So they cannot go beyond that also. If I may just read few lines. The respondent, the appeal is directed against a judgment and order dated so and so passed by the division bench of the Rajasthan High Court, whereby and whereunder an intra-court appeal filed by the appellant herein from a judgment and order dated so and so passed by the learned single judge, affirming an award of the central government industrial tribunal was dismissed. May I just read the reference, paragraph 3. Whether the action of the management of so and so is justified in terminating the service of workman Shri Om Prakash Sharma, so and so, with effect from so and employing another junior workman Shri Vikas Vijay Kumar in his place without giving any opportunity of employment in violation of section 25H of the ID Act 1930. If not, what relief? Before the Labour Code, a contention was raised as to whether the provision of section 25H of the Industrial Dispute Act and Rule 77 of the Industrial Dispute Rules 1957 has been violated, as one Vijay Kumar was said to be junior to him and was said to have been appointed in his place. A finding of fact was arrived at that the respondent failed to prove that after his termination of service, Vijay Kumar was employed in his place in violation of section 20. A finding, however, was arrived at that no seniority record was maintained as is required under the rules. The appellant was thus found to have violated Rule 77 of the IDA. A further finding was arrived at the Rule 77 being mandatory in nature. The respondent was entitled to be reinstated. Though there was no violation of 25H, they went on to examine rules that there is a violation of rules, they were entitled for. So the finding you will find that may read from paragraph 8. I'll read paragraph 8 and 12. The industrial court, it is well settled, derives its jurisdiction from reference. So and so. The reference made to CISD specifically refers to only one question, that is whether any illegality was committed by the management in giving appointment to one Vijay Kumar in place of the respondent in violation of section 25. Non-maintenance of any register in terms of Rule 77 of the IDA rule was thus not an issue. Before the industrial court, the parties adduced evidence and attempt was made by the respondent hearing to show that one Vijay Singh was appointed, although the name of one Vijay Kumar appeared so and so. So, may I go to paragraph 12, the finding?
yes.
The specific issue which was therefore referred for determination by the Labour Court related to the dispute as regard violation of Section 25H of the Act. If the said provision has not been found to be violated, the question of setting aside the order of termination by the Labour Court did not and could not arise. The learned single judge proceeded on the premise that the
One
High
second, 1 second. If the said provisions had not been found to be violated, the question of setting aside the order of termination of the Labour Court did not and could not arise. Yes.
The learned single judge proceeded on the premise that the High Court in exercise of its writ jurisdiction cannot sit in appeal over the award of the Labour Court. The learned single judge was right, but then only because the jurisdiction of a High Court while exercising of its power of judicial review was limited, it would not mean that even a jurisdictional error could not have been corrected. The provision of Article 226 and 227 of the Constitution of India would be attracted if the inferior tribunal has internally committed a jurisdictional error. What would be the ground for judicial review in regard to other? So here, rest of the part is whether if they committed error, obviously your lordship can interfere and set aside it. But the ratio of the judgment is that it cannot transfer beyond the reference. Reference was specific to whether it had committed any violation of 25H, which the Labour Court find that there was no violation of 25H. But there was a violation of the rules of non-maintenance of the seniority. As such, the terminated workman was entitled for reinstatement. That it was held is in violation because that was not a part of the reference, therefore they have committed jurisdiction error. And that was okay. Paragraph 14 is the in the instant case, the award of the Labour Court suffers from an illegality which appears on the face of the record. The jurisdiction of the Labour Court cannot emanate from the order of the reference. It could not have passed an order beyond the terms of reference. While passing the award, if the Labour Court exceeds its jurisdiction, the award must be held to be suffering from judicial error. It is capable of being corrected by the High Court in exercise of its power of judicial review. The High Court therefore clearly fell in error in refusing to exercise review. So here also the Labour Court exceeded the review. The reference was only on domain.
Yes.
Now, on the basis of the evidence has been adduced, I'll come to your lordship's statutory power, but before that, may I just deal with the mandamus part. Because if your lordship now set aside the order of the Labour Court because it is transverse beyond the reference. Now, as to what relief or what, how the lordship will mold the relief, whether it will simply set aside or whether it as a it sit as an appellate court and give further directions. Now, one thing has to be kept in mind, your lordship. This is a private company. And there is no statutory public duty or functions that we are obliged to perform under any act.
Yes.
So, and they has to, the workmen also just say, proof that there is a legal right which they are seeking enforcement.
Mr.
Before all-
Sharma, you're not for the management. So don't use the word we.
No, I'm because I understand, but there's one.
Your submission is being noted. You referred as we are not. That's
Yes.
why, that is where I'm correcting.
Right,
Management is.
managed. I follow.
It's all right.
So whether mandamus can be now issued against a private company, whereupon no public duty is cast on the management. In that regard, I'll just place one judgment, and also whether mandamus can be issued on the ground of sympathy.
This is because on the last occasion, I had indicated
Yes.
that if suppose I find, this court finds that award, in giving the entire reimbursement of that particular bill relating to the treatment at Bombay could not have been done. Whether still on humanitarian aspect can run something else. Something maybe because there is a concession. There is a concession given by the management in their affidavit that the treatment, whatever has expenses till Guwahati, they will pay, they will reimburse. So on that basis, whether this court can mold the release.
I think that is an undertaking on the basis of undertaking, not on the basis of or on the basis of the consent, your lordship can definitely.
But then again, there also the difficulty is the workman never brought any material to indicate what is the expenses that the workman had incurred till Guwahati. The only bill which has been submitted is in relation to the treatment availed at Bombay. There is no material. And the management has also not given a particular figure. So when there is no evidence, yes. This is on that mandamus.
Yes. 2006. Right. 2006. (1969), yes, CR 773. 773.
Where is the citation?
Citation, this is the lordship turn to next page.
Okay, okay.
1969 SCR and the page number would be 773.
All right.
You can turn to page 778.
Page
778,
778.
yes.
Yes.
The third paragraph.
Yes.
In our view, the High Court was correct in holding that a writ petition filed under Article 226, claiming against the company mandamus or an order in the nature of mandamus was misconceived and not maintainable. The writ obviously was claimed against the company and not against the conciliation officer. In respect of any public or statutory duty imposed on him by the Act, as it was not he but the company who sought to implement the impugned agreement. No doubt Article 226 provides that every High Court shall have the power to issue any person or authority orders and writs, including writs in the nature of habeas corpus, mandamus, etc., or any of them for the enforcement of any of the right conferred under Part 3 of the Constitution or for any other purpose. But it is well understood that a mandamus lies to secure the performance of a public or statutory duty, in the performance of which the one who applies for it has sufficient legal interest. Thus, an application for mandamus will not lie for an order of reinstatement to an office which is essentially of a private character. Or can such an application be maintained to secure performance or obligation owed by a company towards its workmen or to resolve any private dispute? In so and so, mandamus was refused against the Industrial Code, those set up under the Industrial Codes Act 1919, on the ground that the reference for arbitration made to it by a minister was not one under the Act, but a private reference. This court has never exercised a general power, said so and so, to enforce the performance of the statutory duties by public bodies on the application of anybody who chooses to apply for mandamus. It has therefore always required that the applicant for a mandamus should have a legal and a specific right to enforce the performance of the dispute. So they should have a legal right. Without any statutory right, they cannot seek for. Therefore, the condition precedent for the issue of mandamus is that one who is claiming it has a legal right to the performance of a legal duty by one against whom it is sought. An order is in the form of a command directed to a person, corporation, or inferior tribunal required by him or them to do a particular thing therein specified, which ascertain to his or her thing. Let me come to the paragraph in the middle here. The company being a statutory body and one incorporated under the Companies Act, there was neither a statutory or a public duty imposed on it by a statute, in respect of which enforcement could be sought by means of a mandamus, nor was there in its workmen any corresponding legal right for enforcement of any statutory or public duty. The High Court therefore was right in. But this was, I must say, this was a writ filed directly. It was not a reference case from the labor court.
Yes.
And there's another judgment I want to show. This 2006-12 SCC 561. Paragraph 15 to 18.
Yes.
In Maruti Limited versus Ramlal, it was observed, while construing a statute, sympathy has no role to play. This court cannot interpret the provision of the said act, ignoring the binding decision of the constitution bench of this court, only by way of sympathy to the workmen concerned. In A. Umranani versus Registrar so-and-so, this court rejected a similar contention upon noticing the following judgment. In a case of this nature, this court should not even exercise its jurisdiction under Article 149, 142 of the Constitution of India or misplace sympathy. This is what your lordship was asking a while back, whether even a labor court or this honorable court can exercise its equity jurisdiction. When even the honorable court, Supreme Court his hands are tied under 142. Next page. In Terry Oates Estate versus so-and-so, it is stated as under. We have no doubt in our mind that a sympathy or a sentiment by itself cannot be a ground for passing an order in relation whereto the appellant miserably failed to establish a legal right. It is further tried that despite an extraordinary constitutional jurisdiction contained in Article 141 of the Constitution of India, this court ordinarily would not pass an order which would be in contravention of a statutory provision. So these are the similar line. So paragraph 16 is a finding. In the facts and circumstances of this case, in our opinion, the High Court should not have allowed the respondent herein to join in service only on the basis of sympathy. It is now well settled, and that in the absence of any legal right, the court should not issue a writ of or in the nature of mandamus on the basis of sympathy. Paragraph 18, we are therefore of the opinion that the High Court committed a manifest error in allowing the writ petition of the respondent. It is set aside accordingly.
So, this matter can also be perceived in this manner that the reference itself presumes that there is no statutory obligation. Isn't it? Now, if that be so, in answering the reference, one has to see whether on humanitarian grounds it can be given or not. Now, in order to, that would depend on the evidence.
Yes.
There was no evidence as regards the expenses that was given and that was incurred outside within the state also. Only thing just about a bill.
In violation of section 10.
And in order to give that, in order to say, answer that reference in favor of the workmen, it would be reading an obligation which is not there in the statute. Because the statute has given the obligations. There is no obligation in the statute for giving cancer treatment, as far as the plantations are concerned. Now, taking a humanitarian approach would mean, in other words, to read cancer treatment in the statute, when the statute doesn't provide. Correct? And that is what precisely the labor court has done.
Yes.
Labor court, let us go to that particular observations.
Page 39.
Yes.
Internal page 10, I think.
Yes.
In the course, third paragraph, in the course of argument, the learned counsel for the workman has contended that as per provision of section 10 of the Plantation Labor Act, the wife of the workman is also entitled for medical facility. At this stage, I would like to retain this act. Thus, from the above position, it is clear that not only the workers, but the families are also entitled for medical facilities.
Once again, just read it again. Number 10.
Number 10. Should I read the section?
Yes, yes.
In every plantation, there shall be provided and maintained so as to be readily available such medical facilities for the workers as may be prescribed by the state government. If any plantation medical facilities are not provided and maintained as required by subsection 1 of the chief inspector, may cause to be provided and maintained therein such medical facilities and recover the cost thereof from the defaulting employer. Now, whether this medical facility is prescribed by the state, but the rule was not considered by the other.
It appears that is why reading this, my first impression after hearing both sides was that the manifest error has been committed because section 10 says that the every plantation shall be providing those those medical facilities which are prescribed by the state, and not giving those facilities, they will then the cost shall be recovered from the defaulting employer. This is what it says. So first and foremost, the labor court ought to have checked the rules and see whether the treatment of cancer is provided or not. That is not done. Yes, and then refuting the submission.
Of the learned counsel for the workmen, the learned counsel for the management has contended that as per rules prescribed under the section 10 of the Plantation Labor Act, there shall be two types of hospital, that is garden hospital and group hospital. But the workman did not follow the procedure of reimbursement. Learned counsel for the management has further contended that the wife of the workman did not take treatment at Viburo Cancer Institute. I have considered the submission of the learned counsel for the management, though there are two types of hospitals, but the management has failed to show the treatment for cancer is available either in the garden hospital or in the group hospital. Due to the seriousness of the disease, the patient went to Mumbai for treatment. When the patient was referred to outside by GMCH, it was a prerogative of the patient where to go for treatment of cancer disease. That apart, the ID Act is a social legislation intended to protect the interests of the workmen employed in various industries. Non-payment of which to the workmen is violation of the principle of natural justice.
See, this particular finding, though there are two types of hospitals, but the management has failed to show that treatment for cancer is available either in the garden hospital or in the group. From where? On what basis?
So here's
This is a perverse finding.
Yes, this is
It's absolutely perverse finding because where is that obligation for the management to provide
Cancer
cancer treatment in those hospitals? That is not discussed. Section 10 has been discussed and straight away a finding has been given without reference to the rules.
yes.
Yes, go ahead.
Thus, from the above discussion, it is evident that the workman has observed all procedure for medical reimbursement. Despite following the procedure, when management of Kapotonga Tea Estate has refused to pay the medical bill of rupees so to Sri Aniltheke for treatment of his wife who was suffering from cancer, which was not justified. Therefore, the petitioner is entitled to get rupees so from the management of
Yes.
Rule 35 provides what kind of facilities are there in the garden hospital.
Yes.
it says to deal with outpatient, inpatient, not requiring any elaborate diagnosis and treatment. Infectious cases, infectious like malaria, and this is prevalent there. Midwifery, simple prenatal and postnatal care for infants and children, and periodical inspection of. So these are very basic things.
Yes. Then group,
Shall be capable of dealing efficiently with all types of cases normally encountered, but will not be used for routine treatment. Admission to group hospital shall be only on the recommendation of the guardian hospital.
shall be capable of dealing efficiently with all types of cases normally encountered. That will not be used for routine treatment. Admission to group hospital shall be only on the recommendation of a guardian hospital doctor. Then guardian hospital,
You can also see 7D,
huh?
7D of the same rule, 36, 7D.
36(7)
D.
D,
The following departments shall be provided.
7D,
Yes.
yes.
General ward for males, general ward for female. Maternity ward with separate labor room. Family planning center, TB and VD clinics, outpatient departments with sufficient waiting space for students. So consulting rooms so arrange the patient can be examined in privacy. Minor operation and dressing room. Dispensary and drugstore, general store, kitchen for cooking, separate small ice. So these are the facilities that has a department that is there.
Then group hospitals, 37.
Yes. This is who has to establish the,
Now there are also 6
yes,
each hospital.
6, 37, 6. Operating theater block, X-ray block, physical therapy block, dental treatment block, labor room, TB and VD clinics, consulting and examination rooms, clinical laboratory fully equipped.
What is VD? Vulnerable disease. What is VD?
I'll just refer to that.
Yes.
Consulting and examination rooms, clinical laboratory fully equipped, dispensary, administrative and office block, kitchen and laundry blocks, laboratories, bathrooms, stores, mortuary,
This does not by any stretch of imagination include cancer.
which is a
treatment.
super specialty, which requires super specialty.
Then
And what is
yes, standard of medical also see equipments and drugs. Every dispensary, garden hospital, 38 shall maintain such equipment and drugs as may be specified. Then 40 standards of medical. These are also all that. And failure, 42 is given.
if the employer does not provide and maintain medical facility as required in these rules to the satisfaction of the chief inspector, the letter will cause to be provided and maintain these facilities in the nearest garden hospital or dispensary on a district board or other similar hospital. Or if you consider necessary, authorized either by general or special order, medical treatment by a qualified medical practitioner or in any hospital that may be found convenient. The defaulting employer shall be liable to pay the cost of such medical facilities, including charges, if any, in respect of the medical officer's visit, the maintenance of sick worker in hospital, transportation provided. In addition to the above, the defaulting employer may be liable to pay a penalty as determined by the chief inspector. We also have provided it.
That list is given at page 142 if you are holding the same book.
And this, I'm not sure whether the reference by the GMC was exhibited or not.
Ms. Bhattacharya, I don't think that was exhibited, correct?
But it says by oncologist MD. So meaning thereby, that is on presumption. GMC at that time didn't have any cancer department. It's recently that is. Refer to outside for MD oncology.
Where is that? That is exhibit number 1. That's the reference. Okay.
Exhibit number A. One is bill submitted by the workman.
Mr. Deka, you are there. When did you join? Yes.
So this references for MD oncology.
You just mark it.
Exhibit A is the registration applied slip matter
Yes.
of DMC.
Okay.
Exhibit A1, my lord, referred to outside for MD oncology. That is 2011-2008.
Just keep it with you.
One where the private hospital says referred to higher center for necessary treatment. Previous page is referred to hospital.
Just keep it with you for the time being. Yes.
So the facilities that are bound provided by the management. It's not statutorily provided. We are not bound to provide this.
Now again using the word we.
And standing at this side.
No, there is no this side. Now you are in a mic case.
Right.
There is no side.
Comes up of time. So ultimately, if I sum up the submission, the labor court has transversed beyond the reference. The references would be limited to on humanitarian ground. He had gone to examine whether there is a violation of statute, which he cannot. That means he has gone beyond the reference and has acted without limit. First. Second is the reference itself is bad. Because if a reference is beyond what is prescribed by law, then the reference is bad. Third, if the award is illegal to any statute or statutory right or the industrial law, then the award cannot be sustained. And
All right.
and mandamus cannot be issued. for
I'm
supreme.
closing it.
The surgery, I'll just play the judgment of the surgery.
Suryadev or Radhesham.
No, this is side A2 prior to. In this one.
You give whatever citations you want to give. Mr. Deka, you had cited any decision? No. Ms. Bhattacharya, please give that list.
Today I have submitted another.
Whatever, you just put the, in a piece of paper, just 1, 2, 3, 4, the decision that you have submitted. So that while I'm recording your submissions, I don't leave any of your case law. Mr. Sharma, you also asked your junior to just put it in a list. The case laws that you are relying. Mr. Deka, if you are relying on anything, just put it in a piece of paper. That's it. 1, 2, 3, 4. Cases relied by respondents.
My submission is that my lord, two Supreme Court decisions, my lord, squarely covers my.
Yes,
case.
I have heard your submissions,
yes.
Ms. Bhattacharya.
Yes,
There is no.
And my,
Only I wanted to have a neutral.
but my learned friend is arguing in behalf on behalf of management, my lord. That's-
It is,
Just placing
that
the
is
judgment.
that is very unfortunate.
He is a young generation lawyer, so he's getting anxious. That is why it's a slip of tongue, Ms. Counsel.
I'm just placing
But
the
that's very
judgment.
unfortunate, my lord.
Lordship, in paragraph in AI 1964 SC 477, I'm relying on paragraph 6, 7, and 8.
AIR 64,
Yes,
6.
7, and 8. And this is related to surgery. And in 2010, 3 SCC 192. Is paragraph 11,
2010,
3 SCC 192. I'm relying on 11, 12, and 13.
11,
12 and 13.
12, and 13. Yes,
I may just read one line. Your
it's
Lordship.
all right, Mr. Sharma. Arguments concluded. Reserved for judgment. We can't get it to the left.
I mean,
Any trouble, your lordship. It is under the weather.
You're not feeling well? Yes.
Item number 28. The last occasion, your lordship, the case diaries were called for.
Item number
28.
28.
Wait. Hearing item, your lordship.
Yes.
Case diary was called for. I've checked with my senior friends. Case diaries have not come yet.
Have you informed the other side?
Yes, RS theory, I have.
All
informed
right.
them.
In item 28, Mr. M. Sharma, learned,
Yes, M. Sharma.
M. Sharma, learned counsel for the petitioner. Who was supposed to produce the case diary? Well, then you say KK Parashar submits that the case diary as required, as called for by this court earlier, is yet to receive. Relist after data that read on such and such date.
So in this case, we have already filed our written argument on my lot 12/12/2024.
So here I have a hearing on behalf of Mr. K. Gogol Lordship. Lordship, Mr. Gogol was supposed to file a compilation for this matter, Lordship. If he has informed me that.
Huh?
He has just informed me that this matter may be taken up if possible after vacation, Lordship. He will file the compilation within the due course, Lordship.
Immediately on opening.
Immediately.
Mention is made on behalf of Mr. K. Gogoi, Learned Standing Council, Higher Education Department. On the ground that the compilation as sought for by this court earlier is in the process. Prayer is allowed. We list on such and such date after for further hearing.
I do.
In this matter, my lord, I had concluded my arguments, and in fact, we have all submitted our written arguments.
This is that matter where I think Mr. Nath was appearing.
Right.
He was supposed to
He was
respond.
supposed to make his submissions and also submit a written argument, which he has done. We have a copy of that. also.
Just written arguments have been given.
Even our written argument was quite long back. It must be also.
Yes, sir.
Yes.
I have the copy. In fact, there are two copies of your written argument, but I think it is the same. Yes. Yes, Mr. Nath.
On behalf of the respondents, I have submitted my submission. Copy here.
Copy for this. Technique even.
On last topic, I have sent a copy to the other side also.
What it is, if you find it for this. Look for written arguments to put us. Now, I have the written arguments of the
On
petitioner.
27/3/25, I have submitted.
There. In fact, there are two copies of the petitioner's written argument. And I think also a response to the respondents.
We haven't filed any response. It's a very short response that I'll
Oh,
take.
then I think I have wrongly, perhaps it is there then. You had used the word response.
We have sent for the stand taken by the respondent in the.
That's why I got confused. Stand taken by.
Yes.
That I,
And-
so
and
I
another-
thought it is your.
The
uh,
response is
reply.
on a point of law.
That,
I'll
that's
take
all.
2 minutes.
That's all right, Mr. Chaudhary. I
and-
actually mistook this to be your reply to the response.
Well, I have indicated the stand taken in the affidavit in 2 paragraphs. And well, the submission is this next week. My submission only on that, on these 2 submissions that I have to make. Number 1, the prosecution sanction order has been passed by the competent authority after considering the materials placed before him. And each case has to be considered on its own merit on the basis of the materials available and the relevant factors. And the second one of the submission is that it is the second proposition of law that when a prosecution sanction order exists, its validity or invalidity shall have to be challenged before the trial court, irrespective of the grounds of challenge. The validity of the sanction order should be determined in the course of trial and not.
So according to you, in this case, the materials are there
Yes,
indicating that the sanction has been given
yes.
by the competent authority.
The second proposition which I have, the validity of the sanction order should be determined in the course of trial and not in the exercise of jurisdiction in a proceeding under Article
Followed.
227. For that, I am placing reliance on these 2 decisions.
Followed.
2012 1 SSC 532.
So copy this one. Here, the challenge is,
Against the sanction order. Which
sanction order is challenged
sanction order is challenge, that is the
on the ground.
page number 94 of the writ petition annexure J, that is 6, 7.
1 second, let me read the petitioner's
Yeah.
argument one.
Lots.
If I recollect, Mr. Chaudhary, your case is that there were 3 persons involved, same set of allegations,
Exactly same.
word to word, same charge sheet, everything is same, but in respect of 2 of them, it was denied. And in respect of the petitioner,
In fact, I have
Yes,
mentioned it in
David.
my written argument.
yes.
There
I
are
read.
4 or 5 considerations which were considered to be germane in respect of the other 2. And those aspects do not even find a mention in my order granting that. So our entire case is based on violation of Article 4. And in fact, in support of that, we have placed some case laws of.
Yes, I think we can now see your case law first.
Yes. Lordship, kindly first take up the 2012
Is it a
2012 1 SSC.
Surya Dev also you have brought? এইকেইটা ইয়াৰ কেছ নহয়। Huh? No, no, these are in that case. You sub confused for yes. It's not. This is a criminal case. This is all. No, no, these are the other case. We are going into CAV hole. The CAV case. No,
I have not given the filter for the effective list of.
everything is. It don't know. Yeah. 2014-11 anybody is appear is relying.
No, but I am relying on two,
Yes, 2012, one is
Well,
it, 2015-16 is it?
I have not given, have given the list of book,
No, but he must have taken a print out.
but I.
April 1, but it was Agore, and it means.
But I can place it for, 10 minutes time, I.
1 second. I think on earlier occasion you may have given. Egita code Nagano de Egita. Yes, which one? 2000?
2012, 153, 532.
Yes.
This is Dinesh Kumar versus Chairman Airport Authority of India.
Yes.
The para 2, 3 the facts. Some relevance is there, but I would like to read the paragraph 2. On 4/11/2009, the sanctioning authority granted sanction to prosecute the appellant for the offence indicated above. After the sanction order was challenged by the appellant in the High Court on 26/11/2009, the charge sheet has been filed by the CBI. The respondent number 2 against the appellant on 30/11/2009 in the court of the special judge Ernakulam. Following that, summons came to be issued to the appellant on 18/12/2009. The dependency of the matter before the High Court, wherein the sanction order has been challenged by the appellant, the court of special judge has taken cognizance against the appellant. The single judge of the High Court was not persuaded with the contentions raised by the appellant and dismissed the appellant's writ petition on 19/7/2010. Against the order of the single judge, the appellant preferred an inter-court appeal. The division bench of the High Court dismissed the inter-court appeal on 29/9/2010, observing that it was open to the appellant to question the validity of the sanction order during trial on all possible grounds, and the CBI could also justify the order of granting sanction before the trial judge. Appellant kindly come to para 6. The submissions are there.
Yes, read.
On the other hand, Mr. H.P. Raval, so-and-so for the CBI, respondent number 2 supported the view of the division bench. He submitted that in a case where validity of the sanction order is sought to be challenged on the ground of non-application of fine, such challenge can only be made in the course of trial. In this regard, he heavily relied upon the decision of
But
the
in this case, I believe the challenge is arbitrariness.
non-application of fine.
Arbitrariness, because you see, you have on the set on the same facts, you have declined in respect of 2 persons, but you have accorded sanction in respect of the petitioner. And where you have already said that those facts are not what is the word used? Not germane.
In my case, what has happened is the considerations that weighed in the mind of the authorities for not granting sanction in respect of the other 2, those considerations do not even find a mention in my order granting sanction. So therefore, we are saying that you have violated Article 14.
The reasons are not there.
Those reasons are not even reflected.
For the article, in fact, the decision, it will be clear from the decision of the further reading of.
Yes,
the
yes,
decision.
please go ahead.
And only as of the sanction order, Logic kindly take note that the sanction order in respect of all the 3 officers, they were not at the same place. They were videos of different.
You have to clarify all that.
The orders, all the 3 orders are video launching.
Because your argument on that written synopsis of the argument that you have provided doesn't talk about all this. You have simply made the submission that if a validity is challenged,
But
this
in
court
fact-
will not go into the validity aspect because the same can be taken care of before the trial.
In fact, Malad, in the submission, Malad, in the stand taken by the affidavit, we have indicated, Malad, in the paragraph number 2, the second paragraph of our stand, we have indicated that Tanmoy Pratim Boragoy and Deepanath Orang. They are the two officers. They served in separate blocks as video for a period of 2 months, 2 months.
Mr.
2 months,
Nath,
2
you
months
have to
for-
slowly take me everywhere. Otherwise, it becomes very difficult.
Definitely.
Yes.
Well, let me place the decisions and then I'll take you back. Paragraph 6, I was reading. On the other hand, Mr. So-and-so, Planet so-and-so for the CBI, the respondent number 2 supported the view of the division bench. He submitted that in a case where validity of the sanction order is sought to be challenged on the ground of non-application of fine, such challenge can only be made in the course of trial. In this regard, he heavily relied upon a decision of this court in Prakash Badal versus State of Punjab. He also relied upon the recent decision of this court in Ashok so-and-so. Well, next para, this court has in Mansukh Lal so-and-so considered the significance and importance of the sanction order under the PC Act. It has been observed therein that the sanction is not intended to be, nor is an empty formality, but a solemn and sacrosanct act which affords protection to government servants against frivolous prosecution and is a weapon to ensure discouragement of frivolous and vexatious prosecution and is a safeguard for the innocent, but not a shield for the guilty. This court highlighted that validity of a sanction order would depend upon the material placed before the sanctioning authority, and the consideration of the material implies application of mind. The provision contained in section so-and-so, section 19, 1, 2, 3, and 4 of the PC Act came up for consideration before the court in Prakash Badal's case in paragraph 47 and 48 of the judgment. The court held as follows. Para 47, 48, the sanctioning authority is not required to separately specify each of the offences against the accused public servant. This is required to be done at the stage of framing of charge. Law requires that before the sanctioning authority, materials must be placed so that the sanctioning authority can apply its mind and take a decision whether there is an application of fine or not would depend on the facts and circumstances of each case, and there cannot be any generalized guideline in that regard. The sanction in the case related to the offense relatable to an act, there is distinction between the absence of sanction and the alleged invalidity on account of application of fine. The former question can be hesitated at the threshold, but the latter is a question which has to be raised during trial. While drawing the distinction between the absence of sanction and validity of the sanction, this court in Prakash Badal expressed in no uncertain terms that the question of absence of sanction could be raised at the inception and threshold by an aggrieved person. However, where sanction order exists, but its validity and its legality and validity is put in question, such issue has to be raised in the course of trial. Of course, in Prakash Badal, this court referred to invalidity of sanction on account of non-application of fine. Para 10, in our view, invalidity of sanction where sanction order exists can be raised on diverse grounds like non-availability of materials before the sanctioning authority, or bias of the sanctioning authority, or the order of sanction having been passed by an authority not authorized or competent to grant such sanction. The above grounds are only illustrative and not exhaustive. All such grounds of invalidity or illegality or sanction would fall in the same category like the ground of invalidity of sanction order on account of non-application of fine, a category carved out by this court in Prakash Badal, the challenge to which can always be raised in the course of trial. And pausing here for a moment, my respectful submission before the honorable court is the grounds which they have taken. I'll take to the paragraphs of the petition. Their basic ground is that you have this is absolute non-application of fine. Whatever materials you have placed, you have not considered properly because similar set of facts, similar set of materials were placed. In respect of others, you have not given sanction. In respect of the petitioner, you have given sanction. Well, my respectful submission is whatever ground you have taken, because the honorable court in clear terms it has said that the grounds, whatever it has been mentioned here, those are not exhaustive but illustrative. Application of mind, materials are not sufficient, or whatever it is. Everything, if the sanction order exists, then the law is not that you have to, during the course of trial, you have to challenge them. Because the other side will also get an opportunity that those materials were properly considered at that point. Then we'll kindly come to para 13. Para 13, in our view, having regard to the facts of the present case, now, since cognizance has already been taken against the appellant by the trial judge, the High Court cannot be said to have erred in leaving the question of validity of sanction open for consideration by the trial court and giving liberty to the appellant to raise the issue concerning validity of the sanction order in the course of trial. Such course is in accord with the decision of this court in Prakashing Badal and not just unjustified. Then para 16, in view of the above contentions and the factual,
Here
And-
also the trial has started.
in fact, they have also filed in the writ petition, they have filed a criminal petition. There, an order was passed
Same.
in criminal petition page number 125, annexure I. They have challenged that order of cognizance and the criminal petition 86 of 2015, Honorable Court has stayed the order. The proceeding of the-
Cognizant otherwise has been taken.
Yes, proceeding has been stayed. And the
Now, if the cognizant goes, then this can be challenged before the cognizance court. This is what you're trying to say?
no, my respectful submission is,
No, because why I'm asking you this, it appears that the stage for challenging the sanction is prior to the cognizance,
after
after the cognizance.
the the criminal proceeding is going on. Now they have challenged the sanction.
All right, sorry. I misread the all right,
They have challenged the sanction.
okay.
This is very clear. This has clarified that if the sanction, there are two situations. One is sanction order exists, other is sanction order is not there. If the sanction order is not there, that can be challenged. If the sanction order exists, on whatever ground, if you are agreed by the sanction order, you have to challenge it for the trial. That is the position. The second decision, which I am relying, kindly see,
Yes.
2015-16 FCC 163. But here the decision, earlier decision, 2012, that has been, in fact, that has been also discussed. Kindly come to the paragraph number 5. But para 1, it will make it clear. The challenge hearing is against the order dated 11-1 para 1, 11-1-2013, passed by the High Court of Delhi, a writ petition registered as the application number so and so, by which the order dated 21-10-2009, granting sanction for prosecution of respondent number 1, Ashok Kumar Ashwal, has been interfered with by the High Court. Agreed, the CBI and the Union of India have filed the present appeal. Para 5. It appears that CBI submitted a report recommending launching of prosecution against both the officers under different provisions of Penal Code 1860, as well as the Prevention of Corruption Act 1988. CBI also has recommended regular departmental action against the said two officers. While the matter was under process, there appears to have been some difference of opinion at certain level as to whether sanction for prosecution should be granted against both the officers or against Rajiv Agarwal alone. Similarly, there was difference of opinion as to whether a departmental proceeding for imposition of a major or a minor penalty should be instituted. It appears that on 11-9-2007, sanction for prosecution of Rajiv Agarwal was accorded by the competent authority, and in the proceedings filed before the learned trial court, the respondent number 1 was also shown as accused, and sanction for prosecution of respondent number 1 was stated to be awaited. While the matter was so situated, the learned trial court discharged respondent number 1. As admittedly, at that point of time, there was no sanction order for his prosecution. Subsequently, the matter concerning sanction for prosecution of respondent number 1 was taken up, and eventually sanction was accorded in the file by the Finance Minister on 8-8-2009, on the basis of which a formal order granting sanction was issued on 12-8-2009. It also appears that on 14-9-2009, a corrigendum was issued to the effect certain corrections in the sanction order dated 12-8-2009, whereafter another sanction order, revised sanction, was issued on 21-10-2009. It also appears that in the letter of the Undersecretary concerned to the government of India, Ministry of Finance, Department of Revenue, Central Board of Excise and Customs.
You
Communicating
have
this,
the records.
Logic.
You have the records.
No, madam, the sanctioning authority, the record I don't have, right? At this moment, I don't.
Yes.
The communicating the sanction order dated 21/10/2009 to the appellant. It has been mentioned that the earlier sanction order dated 12/2009 and the originum thereof dated 14/9/2009 has been superseded. The Delhi High Court, on consideration of the matter, took the view that the grant of sanction in the instant case by the competent authority was at the behest of CBI, and same does not disclose a fair and independent application of fine. The High Court also took the view that the subsequent sanction order dated 21/10/2009 was without the approval of the sanctioning authority. On the aforesaid two grounds, the High Court thought it proper to interdict the order dated 21/10/2009 granting sanction for prosecution of respondent number 1. Kindly come to para 9. The learned additional so-and-so has further submitted that present is a case wherein sanction has been granted, and therefore on the authority of the decision of the case of this court in Quashing Badal versus State of Punjab and Dinesh Kumar versus Airport Authority, which I have read all of 2012, the High Court would not have interdicted the decision to grant sanction at a threshold. At best, the High Court could have left the matter for determination in the course of trial. Controverting the submissions has been made. Lordship may kindly come to paragraph 13.
Yes.
We have considered the submissions advanced. We have also examined the records in original place before us. Having perused the said records, we do not find that at any point of time sanction was refused by the competent authority for prosecution of respondent number 1, Ashok Kumar Aswal. There was no dispute that the competent authority to grant sanction in the present case is the finance minister. Before the matter reaches the finance minister, naturally, it has to be processed at different levels, and what we find from the notice in the original file is that certain authorities at different levels may have taken our view, one view or the other of the matter. All such views which were earlier recorded in the file voting were placed before the finance minister by cataloging the events in chronological order. It is on a consideration of the totality of the facts, including the manner in which the matter had been processed at different levels, that the finance minister eventually accorded his approval for grant of sanction on 8/8/2009. The file, in fact, had not reached the finance minister at any earlier point of time. Not this I have referred because, but at many states, the considerations at various levels, ultimately the sanctioning authority is the the competent authority has given the sanction order. There is no challenge to that. Kindly come to para 15, the final. In fact, all the original does is to split up the alleged reduced demand of bribe into two separate amount of rupees 25 lakhs each instead of a lump sum amount of rupees 50 lakhs as mentioned in the sanction order dated 12/8/2009. The Purijatam also dispense with certain provisions of IPC. The aforesaid exclusion of some of the specific provisions in IPC really works for the benefit of the respondent number 1 accused and not of his prejudice. If the Purijatam does not, as we are inclined to hold, effective substratum of the sanction granted initially on 8/8/2009, 12/8/2009, we will have no reason to take the view that initial sanction order has in any way have been modified or altered so as to require the approval of the finance minister once again. Surely, for correction of typographical error, the file need not have been traveled all the way up to the finance minister once again. The fact that the said sanction order has been superseded may have been mentioned in the letter of the undersecretary communicating the said order dated 21/10/2009 to the appellant. However, what is of relevance is that the said fact of supersession is not supported by reference to any authority or decision in the file, therefore, would not deserve any further attention of the court. All the above part, time and again, this court has laid down that the validity of a sanction order, if one exists, has to be tested on the touchstone of the prejudice to the accused, which is essentially a question of fact, and therefore should be left to be determined in the course of trial and not in exercise of the jurisdiction either under section 482 of the Code of Criminal Procedure 1973 or in a proceeding under Article 226, 227 of the Constitution. I am placing reliance on this. whatever is the circumstance, if the sanction order exists, then my lord, under every circumstance, my lord, we have to be there. We have to go to the trial. There are 16, my lord.
But suppose if the sanction order is manifestly, palpably erroneous, blatantly erroneous on the face of it.
My lord.
Then
So, in fact, for whatever ground the person takes against the sanction order, ultimately, court has said that it involves factual effect. So the factual determination it requires evidence, and that has to be reported file. That is the clear finding, sort of the clear finding that you are doing in this case. But here, my lord, the sentence, my lord, all the above apart, time and again, this court has laid down that the validity of a sanction order, if one exists, has to be tested on the touchstone of the prejudice to the accused, which is essentially a question of fact, and therefore should be left to be determined in the course of trial, and not in the exercise of jurisdiction, either under section 482 of the Code of Criminal Procedure 1973, or in the proceeding under Article 226, 227 of the. Because it requires a factual determination. Now what they have said, kindly consider. They said that similarity charge, similarity material in respect of one, you have considered in respect of you have considered differently in respect of me.
ultimately it's all factuous.
These are factual aspects. But the determination of fact has to be before the trial by adducing evidence. You will get the opportunity. but
Whether the facts are similar or not.
yes, because the ultimately what they have for the what the petitioner has argued before the Honorable Court, Article 14. Now, Article 14 cannot be stretched to that extent that we three officers in three different blocks. One has served for 2 months, one has served for 2 years, 2 months, 15 days.
That, see, suppose this court finds merit in your submission to the extent that these are factual aspects which needs to be raised before the trial.
Not
In that situation, this court need not go into the other aspect, whether these are in violation of Article 14 or not. Because that is something which the trial court has to see.
that is why
Your submissions is that once the sanction order exists, this court in exercise of 226 shall not look into the validity aspect.
and
That
this
is your submission,
that-
and you
that
are
is the-
relying on these decisions. According to you, this is a settled position of law.
this is
Whatever reasons could it be, ultimately these are factual,
these are factual.
because once it is there, it is there.
It is-
The sufficiency, the ground, that this court shall not go in.
Ultimately, the materials which were placed before the sanctioning authority, well, that has to be placed, and that can be questioned by the petitioner during the file. How that material has been appreciated, because the sanctioning authority is a witness, has to be a witness before the trial court. He has to appear before the trial court, and he has to support the sanction order passed by him. He will be cross-examined by the petitioner. That this document, how can you come to the conclusion by going for these documents? These are factual determinations. He will be cross-examined, and he can support the material which was placed before him at that point of time. This requires a factual determination. Therefore, in my submission, I am very specific while submitting my submission to the Honorable. Now, 2 submissions I have made. That is why I have not touched those things. The stand taken I have mentioned in my written submissions, I have indicated that these are all the 3 orders. In fact, the petitioner has brought on record all the 3 orders. The 3 orders are apparent. That is the stand we have taken, and we have also said, that the materials placed before the sanctioning authority has been considered, and with due application of mine, that has been passed.
Amendments in your affidavit.
Yes, we have said so.
Where is the sanctioning order, the impugned order page?
Impugned order, Lordship will find at page 94, Annexure G. In the writ petition.
there were three separate orders
False.
for in respect of the three persons.
Three
One.
separate orders.
Two declined, one,
94, 96 and 98.
your one is 20
Mine-
and 96, normal putting more one.
No, mine is 94.
Okay.
The other two are 96 and 98. I have indicated in our written argument.
Para 13 of our affidavit.
One second, Mr. Nath. Yes. Paragraph,
Paragraph 13 of our affidavit. We have said that the
13.
one, yes, one 30, internal page is 5. Ikramul Hussain has filed it. Before the Ikramul Hussain.
One second. Paragraph,
13.
yes.
But we have said that the prosecution sanction was granted by the authority, considering all aspects and records, taking each case individually and with due application of mind. Therefore, it is not true that the opinion of the so-and-so was not placed before the respondent authorities or deliberately kept away or deliberately ignored by the respondent. It was an allegation made in that particular paragraph. We have said that the records, materials placed before the authority against each officer.
Records should be essential.
If logic that is not, I can produce the record.
Because records will show. Because the sanctioning order does not speak of anything. You see, you definitely have made a point that once it exists, this code will not go. But this code is exercising a 226 jurisdiction. The decisions of the apex code are in the context of the facts of those cases. They are contextual, correct? Now, here is a situation where it appears that in respect of two officers, though situated at different blocks, you said. But similar set of allegations, they were denied. In respect of petitioner, it was granted. Now, what was the reasons? That is not discernible. Perhaps from your records, it will be discernible. It can be found out. Because you are not saying, you are only simply saying in your affidavit, was granted considering all the aspects and records, taking each case individually and with due application of mind.
In
But
paragraph.
what is this individual treatment that you have given, how you have considered? These are not discernible.
in
Of
par-
course, first I have to decide whether this code will go into that or not. But let us have the records.
Paragraph number 4 of the affidavit. We have said in the
Why don't you place the relevant paragraphs? You
Yep.
have taken me straight away to paragraph 13. Yes,
Malad,
4.
paragraph-
Read 4.
paragraph 4. This is the stand taken, Malad, I have indicated, Malad, after receipt of the proposal for sanction against the petitioner and others, the prosecution sanction against the petitioner was issued by order dated 6/7/2013. The petitioner, who was the then BDO of the Duyang Valley Development Block, was functioning as program officer in the block with effect from 8/8/2006 to 7/7/2007. And he was responsible for proper implementation of the scheme, such as MNREGA, so-and-so, etc. The deponent respectfully states that from the available records, it is found that the petitioner entered into a criminal conspiracy with his subordinate and staff to misappropriate public money for personal gain, and hence the authority, after due consideration of the materials available on record, issued the prosecution sanction order against the petitioner by order number so-and-so dated 6/7/2013. Next paragraph, next page. The deponent further respectfully states that the prosecution sanction against three so-and-so and so-and-so were denied by the authority as after careful examination of the proposal for prosecution and relevant records furnished by the CBI authority, along with the assets and liability statement of so-and-so and so-and-so. And also considering that both the officers served in the Doyangra development block for a brief period of 2 months and 2 months, 25 days respectively. Criminal intent to earn wrongful gain on the part of the opposite two officers seems not feasible. Therefore, prosecution sanction against them were reduced by order dated.
The
order dated
concerned
6/7.
block is Diangbra Development Block.
There, one is Jiangbra, yes. The other two officers, that block is different. And in respect of the petitioner hearing, it is Dium Valley Development Block is
Which one? Diong?
Dium Valley Block. Paragraph 4, we have indicated the petitioner who was the dam video of Dium Valley Development Block.
Diong Valley Development.
The order is also.
And he was there for almost more than a year.
More than 1.5 years. About 1.5 years.
These are the two distinguishing factors that you're trying to say.
Yes,
They're related to different blocks.
and brief period and their assets and liabilities things they have also seen. And ultimately, after considering all the materials placed before them, the authority has granted sanction order. But the sanction order, since my submission is that against the sanction order, whatever ground is available to him, he can take the ground during the trial. In fact, the authority who has given the sanction order, he has to be present himself before the court, and he has to face all the things, all the questions. How the materials have been appreciated, how he has considered. Those are all factual things. The petitioner will get the opportunity. So the question is not how the petitioner is prejudiced. So it relates to the ultimately question is not the prejudice caused to the petitioner by the sanction order. Therefore, honorable court has time and again has held that it needs a factual determination. So it has to go to the trial. So therefore, madam, I respectfully submitted before the honorable court. My two submissions are that the prosecution sanction orders have been passed by the competent authority after considering the materials before them. And the settled proposition of law is that once the order exists, it has to be challenged before the trial. Not under 226, on whatever, because the honorable court, while deciding the case, I have indicated the paragraph. I have also noted the paragraph numbers. While the honorable court has said that the grounds the honorable court has mentioned in the judgment are illustrative only, not exhaustive. And in fact, the honorable court has also indicated that why it is so. Because it relates to the prejudice. Now ultimately, what the petitioner is arguing before the honorable court. Violation of Article 14, that similar treatment has not been given to them. Because of taking a cue from their argument, I would submit.
One second. Yes.
I would humbly submit that ultimately referring to Article 14, what they are pressing before the honorable court. The prejudice that somebody has been left out. I have been. So ultimately, some prejudice must be hit. That is what he wants to say. The petitioner wants to plead before the honorable court. So that is the issue.
And whether arbitrary treatment given, not given is also factual aspect.
It's a factual aspect. Whether he has been, whether the materials have been appreciated properly or not, ultimately it has to be decided factually. Therefore, my respectful submission before the honorable court of Judicial that this certain position, it's very clear. So lordship may not entertain this kind of petition. Otherwise, the position which is settled by the honorable apex court time and again, that cannot be.
All right.
So my respectful submission is not. The cognizance was then taken, the sanction
Uh-huh.
order is there. Cognizance was taken by the court, sanction order is there. And therefore, this writ petition, this writ petition for doesn't, has no merit. And it refers to the next.
Mr. Chaudhary? What do you have to say about these two case laws?
That is what I was straight away coming. Your lordship will first take up the next one. Basically, as I have understood, my lord, the submission on behalf of the state that he will always get an opportunity before the trial to question the validity of the sanction. Therefore, your lordship will not touch it. Now, let us take up Dinesh one.
Yes.
Your lordship first comes to paragraph 6. My learned friend had placed this, but I would like to place
Yes,
it once
yes.
again. What was the contention on behalf of the additional solicitor general? Para 6.
Yes.
On the other hand, Mr. H.P. Rawal, learned additional solicitor general for the Central Bureau of Investigation, respondent number 2, supported the view of the division bench. He submitted that in a case where validity of the sanction order is sought to be challenged on the ground of non-application of fine, this is the only ground taken. Such challenge can only be made in the course of trial, because this is what has been held in the case of Prakash Singh Badal.
Yes.
Is repeated again, para 9 and 10, my learned friend had placed. Again, place it once again. While drawing a distinction between the absence of sanction and invalidity of the sanction, this court in Prakash Singh Badal expressed in no uncertain terms that the question of absence of sanction could be raised at the inception and threshold by an aggrieved person. However, where sanction order exists, but its legality and validity is put in question, such issue has to be raised in the course of trial. Of course, in Prakash Singh Badal, this court referred to the invalidity of the sanction on account of non-application of fine. This is again the only ground in Prakash Singh Badal. Now, in this context, the Supreme Court says what with this in para 10. In our view, invalidity of sanction where sanction order exists can be raised on diverse grounds like non-availability of material before the sanctioning authority, or bias of the sanctioning authority, or the order of sanction having been passed by an authority not authorized or competent to grant a sanction. The above grounds are only illustrative and not exhaustive. All such grounds of invalidity or illegality of sanction would fall in the same category like the ground of invalidity of sanction on account of non-application of fine, a category carved out by this court in Prakash Singh Badal, the challenge to which can always be raised in the course of trial. And in this context, the Supreme Court says that your lordships will not exercise jurisdiction under either 482 CRPC or 226. Now let us see the other judgment. 2015. Here, it's very interesting. Like in the present case, there were two officers involved. One is the person who approached this, ultimately matter went up to Supreme Court. He is Ashok Kumar Aswal. And there is this other officer involved, Rajiv Agarwal. At paragraph 5, your lordship will find that sanction in respect of Rajiv Agarwal was already granted. Let us read paragraph 5 once again. It appears that CBI submitted a report recommending launching of prosecution against both the officers under different provisions of the Penal Code, as well as the Prevention of Corruption Act. CBI had also recommended regular departmental action against the said two officers. While the matter was under process, there appears to have been some difference of opinion at certain levels as to whether sanction for prosecution should be granted against both the officers or against Rajiv Agarwal alone. Similarly, there was a difference of opinion as to whether a departmental proceeding for imposition of a major or minor penalty should be instituted. It also appears that on 11/9/2007, sanction for prosecution of Rajiv Agarwal was accorded by the competent authority, and in the proceedings filed before the learned trial court, respondent number 1 was also shown as accused, and sanction for prosecution of the respondent number 1 was stated to be awaited. In respect of Agarwal, sanction was already granted. In respect of Aswal, sanction was awaited. While the matter was so situated, the learned trial court discharged respondent number 1 as admittedly at that point of time there was no sanction accorded for his prosecution. So the learned trial court discharged. And it is at a later point, my lord, para 6. Subsequently, the matter concerning sanction for prosecution of respondent number 1 was taken up and eventually sanction was accorded. It is against this subsequent according of sanction that the matter came up before the court. And it is in this context. Now let us see what the Supreme Court records in respect of the findings, para 13. We have considered the submissions advanced. We have also examined the records in original place before us. Having perused the said records, we do not find that at any earlier point of time, sanction was refused by the competent authority for sanction of prosecution of respondent number 1, Ashok Kumar Aswal. There is no dispute that the competent authority to grant sanction in the present case is the finance minister. Before the matter reaches the finance minister, naturally, it has to be processed at different levels. And what we find from the notings in the original file is that certain authorities at different levels may have taken one view or the other of the matter. All such views which were earlier recorded in the file notings were placed before the finance minister by cataloging the events in chronological order. Next sentence, Madam. It is on consideration of the totality of the facts, including the manner in which the matter had been processed at different levels, that the finance minister eventually accorded his approval for grant of sanction on 8/8/2009. The file, in fact, had not reached the finance minister at any earlier point of time. So the Supreme Court takes note of the fact that the totality of the facts were before the finance minister, and the finance minister actually took note of the totality of the fact. And it is in this context, it is said that it is best left open to the trial court. Now let us see the case in hand. Here is a case, my lord. In fact, if your lordship comes to, I won't take your lordship through these materials once again. There are 5 considerations. If your lordship takes up the second page of our written argument.
1 second. Yes,
In fact, the 4th line, identical facts. The only difference, my learned friend has been fair enough to point out that the only difference in facts are 2. Number 1, the duration of their posting is little shorter than me. And the other fact is the blocks are different. But if your lordship peruses the charge sheets, identically worded, only some facts and figures here and there are different. Now, fourth line, there is a sentence starting the protection.
yes.
The protection guaranteed under Article 14 of the Constitution of India has been violated with all impunity, particularly since various relevant considerations in case of the petitioner, such as brief tenure in the post of in charge video as additional charge. Mine was also equally brief, and I had in fact submitted a representation that released me from this additional charge because I am not able to take care of both the blocks. For me, it was only additional charge. Now, having been made to serve against his will, in spite of my representation, they forced me to continue. They did not accept my representation. Primary responsibility of the principal secretary and project director for implementation of NREGA. In case of the other 2 persons, they say that the responsibility lies with the principal secretary. The only difference is that I am in a different block. Yeah, other 2 persons are in a different block. In their case, when it comes to responsibility, in my case, it becomes my responsibility. In their case, it becomes the principal secretary's responsibility. Assets and liabilities not being disproportionate to known source of income. In my case, there is no finding that it is disproportionate. In fact, that aspect is not even gone into. Now, last and most importantly, the opinion of the learned Advocate General Assam were entirely these 5 aspects which were considered in case of the other 2 were not considered. And therefore, we are alleging violation of Article 14.
But Mr. Chaudhary, one thing. You want water?
I'm grateful.
Fine, dear.
It's all right, man.
It's all right. Not good. What is in my mind right now is, admittedly, these are 2 different blocks.
Blocks are.
Correct? Admitted to.
Admit.
Now, in the case of the other two persons who are not connected to this particular offense, because this is a different law.
Offenses alleged are identity,
No. Offense alleged are identical, but different,
different blocks.
different blocks, different. The facts of the, it is relating to different transaction, correct?
Precise.
Now, in that, the authorities relied on the AG's.
I'm grateful one.
Now, in that case, the authorities relied on the opinion given by the AG, had taken into account also the assets liability, perhaps maybe because the duration was only for 2 months. Because that was also an important
Everything
aspect.
else.
Correct.
Correct.
The rest, everything is same. The factum, the allegations are same. Now, in your case, appears to be more than 1 year. The fact that you have written a letter to relieve yourself, now these are all factual aspects.
My lord.
Correct. These are factual aspects. Now, whether any AG opinion taken, not taken in respect of your case.
So it was a common opinion. That is what we pointed out. In fact, we have annexed the learned advocate general's
Where is that?
opinion.
Where is that? Just refresh me there.
Your lordship will find it in our rejoinder one. It was a general opinion covering all the officers against whom charge sheets were filed.
Yes. I am inclined to accept the views of the department proceeds proposing to deny sanction in the facts and circumstances. So that is why you have been saying whether this has been taken into care, consideration or not.
In fact, my lord, as it appears from the learned advocate general's opinion, all through the department had taken up a position that sanctions should be declined. Now, the learned advocate general gives a general opinion that I agree with the position taken by the department. So how is it that in my case, I was completely singled out? They would have to now, if your lordship goes back to the impugned order, they have to at least record that we are changing our position. We are going against the learned advocate
These
general.
have not been recorded.
Nothing, Mal. In fact, these
The only
considerations.
difficulty is the order of the apex court where they said that it can be, where is that?
My lord, it is in the second case.
Second case, no? No.
So, in Dinesh Kumar,
Yes, yes. Here it says, in our opinion, in our view, the validity of sanction where sanction order exists can be raised on diverse grounds, like non-availability of material before the sanctioning authority, or bias of the sanctioning authority, or the order of sanction having been passed by an authority not authorized or competent to grant such sanction. The above grounds are only illustrative and not exhaustive. All such grounds of invalidity or illegality of sanction would fall in the same category like the ground of invalidity of sanction on account of non-application of fine.
my simple, my lord, response to this would be the Supreme Court, by way of a judgment rendered, cannot nullify the power conferred by the Constitution under 226. 226 says that if your lordship kindly has a look at the language employed in 226. This is a constitutionally conferred power on your lordships under 226. This cannot be, by way of a judgment, nullified.
Yes.
Notwithstanding anything in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue any issue to any person or authority, including in appropriate cases, any government, within those territories, directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for what the purpose is this one. For the party. So, if your lordship finds that there is a violation of Article 14, that power could not simply have been curtailed either by Dinesh Kumar or any judgment, even by the Constitution Bench. This is a constitutionally conferred power. And here, specific cases that blocks might be different, but the charge sheets are identical. It is a common Advocate General's opinion that they have taken. Here, in respect of two officers, they say that his assets are not found to be disproportionate. In my case,
I want to say that here is a case where there is a patent error on the face of the, apparent on the face of the record.
discriminate, a hostile discrimination for the simple reason that reasons that persuaded them to decline, the same reasons were never even
Why
considered.
I use the word error? Because according to you, the AG's opinion has not been taken into account.
They don't even refer to the Advocate General's opinion. They don't even say that in my case, my assets are disproportionate. They don't even go into.
See, that I don't know, but it looks like because the other two persons' duration was only 2 months, perhaps in that context, the assets and liabilities perhaps would have had some.
But they should have, they ought to have,
Perhaps, I don't know.
they ought to have taken it into account, and they ought to have said that there is a
Which is,
disproportion.
can we now see the power of the, the manner in which the power which is given in the PC Act? Sanctioning, where
Correct,
under which provision the sanctioning.
But
is
before
required.
that, my lord,
Yes, yes,
if your lordship
Yes.
permits me,
yes, please.
the submission that has been advanced is purely because the power lies with the trial court to look into the validity or otherwise of a sanctioning order. He will have ample opportunity before the trial court. And therefore, your lordships, it is more like saying that there is a alternative remedy in existence. So why should your lordships intervene? It is like saying, in various cases, even when there are arbitration clauses, your lordships intervene. When? Whirlpool Corporation, the Supreme Court has made the position very clear that
See,
even if there
continue.
is, and later judgments also, even if there is an alternative and efficacious remedy, but there is a violation of Article 14, a violation of the fundamental right.
Yeah, the problem is because of these two decisions. These two decision is,
But again,
otherwise,
this does not prohibit
understand the
exercise.
decision, the decisions of apex court are contextual.
Right.
But, in the context of that particular facts, the
If we
apex court
understand,
went ahead and said there could be diverge situations,
I appreciate,
bias,
but
and,
those diverse situations cannot, my lord. In fact, that is why I wanted to place some of the judgments, which I have very briefly indicated. May I place a
yes,
few of them?
yes, yes,
Your
please.
lordship is, I won't
I'm
trouble you.
hearing you. You have the entire
But
second half. No.
one of the first is that leading judgment Dwarkanath. What does the Supreme Court say here?
Citation is given.
My lord, in fact, all the case laws, printouts were already there
Yeah, you
on the last occasion. এটা bunch এটা আছিলে।
second.
I'll-
Yes, which one?
Dwarkanath, my lord, 66 Supreme Court. Here, 66 Supreme Court, 81.
Yeah, I wait till we discuss the whole case in image. Did you post the yellow one as well?
That is why, my lord, we have summarized our submissions.
Yes.
If your lordship just quickly has a look at our
Written argument.
If you, that blinders in mind, we will have to epilepsy. Confusion. Yes.
If your lordship has a look, we have kept it very brief. That when is it that Article 14 will stand violated? We have placed two case laws on this matter. If equal treatment is not given to similarly circumstanced persons, it would violate Article 14. On this point, my lord, we have given two judgments. If relevant factors are not considered, it fails the Wednesbury test and therefore would be irrational, arbitrary and unreasonable, thereby violating 14. And to, my lord, negate this point, that your lordships will maintain a hands-off attitude merely because the trial court has power. That would not apply in the context of Article 226. My lord. If your lordship will kindly have Dwarkanath para 4. My lord.
Arms are long enough
Long
wherever
enough.
there is
And in
illegality.
fact, the language employed is, this article is couched in, my lord, I'm reading the second part, just after, my lord, the Article 226 is quoted in para 4, just after that, my lord, the very
Yes.
first sentence. This article has, my lord, I'm sorry,
Para 4.
para 4.
Yes.
At the beginning of para 4,
Yes,
226
yes,
is,
this article is couched.
this article is couched in comprehensive phraseology, and it expressly confers a wide power on the High Court to reach injustice wherever it is found. This is what I'm relying on. And in fact, let me read the whole paragraph. This will make the position clearer. The Constitution designedly used the wide language in describing the nature of the power, the purpose for which, and the person or authority against whom it can be exercised. It can issue writs in the nature of prerogative writs as understood in England. But the scope of those writs also is widened by the use of the expression nature, or the said expression does not equate the writs that can be issued in India with those in England, but only draws an analogy from them. That apart, the high courts can also issue directions, orders, or writs other than the prerogative writs. It enables the high courts to mold the reliefs to meet the peculiar and complicated requirements of this country. Any attempt to equate the scope of the power of High Court under 226 of the Constitution with that of the English courts to issue prerogative writs is to introduce the unnecessary procedural restrictions grown over the years in a comparatively small country like England, with a unitary form of government, to a vast country like India functioning under a federal structure. Such a construction defeats the purpose of the article itself. This is what I was relying. This is a purely procedural aspect that the trial court has the power to look into it. So therefore, your lordship will not look into it. The reason is very simple. When equally circumstanced people are being not treated equally, it amounts to violation of Article 14, and it is in such circumstances that the framers of the Constitution conceived of a wide power as in 226. Now, my lord, there is another, that common cause judgment, 1999. 1999, volume 6, SCC 667.
Yes.
Your lordship may turn to para 40.
40.
40.
Yes. Yes, please.
Para 40. Essentially, under public law, it is the dispute between the citizen or a group of citizens on the one hand, and the state or other public bodies on the other, which is resolved. This is done to maintain the rule of law and to prevent the state or the public bodies from acting in an arbitrary manner or in violation of that rule. The exercise of constitutional powers by the High Court and the Supreme Court under Articles 226 and 32 has been categorized as power of judicial review. Every executive or administrative action of the state or other statutory or public bodies is open to judicial scrutiny, and the High Court or the Supreme Court can, in exercise of the power of judicial review under the Constitution, quash the executive action or decision which is contrary to law or is violative of fundamental rights guaranteed by the Constitution. With the expanding horizon of Article 14, read with other articles dealing with the fundamental rights, every executive action of the government or other public bodies, including instrumentalities of the government, or those which can be legally treated as authority within the meaning of the Article 12, if arbitrary, unreasonable, or contrary to law, is now amenable to writ jurisdiction of this country under Article 32 or the High Court under 226, and can be validly scrutinized on the touchstone of the constitutional value. So, even when there is an efficacious alternative remedy, if your lordship finds that these tests are not being met, like for example, the reasonableness, if not met, there are judgments after judgments which say, right, from Tata Cellular onward, if Wednesbury's test is not met, it violates Article 14, and that's when your lordship's power under 226 comes in. So here again, if the interpretation as sought to be advanced by the state is to be accepted, it will virtually amount to nullifying the power under 226. I am absolutely not opposed. Had it been a case of merely saying that there is a non-application of mine, certain factors ought to have been considered, have not been considered. Had it been merely that, your lordship would have relegated me to the trial. But here is a case, absolutely identical, but for those two different shading factors, different block and shorter duration. But all other factors are common. The allegations are identical. The situation that prevailed in NC Hills was identical. The fact that all through the department was taking up a position that they should not, sanction should not be granted was identical. The learned advocate general's opinion is identical. So in that situation, whether your lordship will allow such a discrimination to be meted out to the petition, that is the question.
There is another way of thinking. Suppose this court finds that not granting sanction to those two persons, the authorities have done the garrett. They should have.
But that your lordship,
Then now, because the allegations are there. Allegations are there, you see. But that is where I'm finding difficulty. Allegations are there, but it appears in respect of those two people, they have not granted sanction. And because of that, you are saying that I have been treated discriminatory. This is where you are saying Article 14 is being violated. Correct.
not only on that, I am taking it a step further. I am saying that the factors that led, like for example, one of the biggest factors was disproportionate assets was not in existence in their case. Why didn't they check whether my assets were proportionate or disproportionate?
That can also be taken care during the trial court, that aspect, because that decision, in fact, you also said
Yes.
not if relevant things not taken or
No,
that can be
I'm not on
taken
that one.
care of.
I'm not even on that. It is, I'm not
Now,
saying that.
this assets thing indicates the discrimination. In essence, you are trying to build up that Article 14 accused.
Absolutely.
Correct. Now, suppose we go to that Article 14, merely because an illegality has been has happened, should we perpetuate that illegality here also?
Your lordship would not apply the test of negative equality in this particular case for the simple reason. Two aspects are there. Number one, not only have they been refused sanction, they have in the meantime got promotions, they have one of them. The reasoning, I am not on the correctness or otherwise of the reason. Here is a case, to apply the test of negative equality, there has to be a clear finding that those refusals were wrong. Here it is not that situation. Here is a situation whether the considerations that led to passing of these orders granting refusing, would the same considerations were they not supposed to be applied to me equally? That is the test here. Because here is a case where we cannot go into those refusals, orders refusing, to see whether they were correct or not. The test of negative equality would come in when on the face of it, something illegal has been allowed to happen. And based on that illegality, someone comes with a case and says that he has been treated like that, give me that, give me a similar treatment. Here, that stage would not, will not even come, because your lordship would not be going into that aspect. Your lordship will, just to show the difference, if your lordship kindly
Yes.
has page 94 and 96 simultaneously. The difference in the treatment will be apparent on the face of it. Page 96 is one of the officers. In fact, my lord, if your lordship first has page 96 and 98, these are the other two officers.
Yes.
Your lordship will find, except for the names of the officers, even the commas and the full stops are the same, 96 and 98. Word for word, full stops, commas, semicolons, everything same.
Yes.
And your lordship will kindly
94.
my lord will kindly first come to page 96, the last paragraph in page 96.
Yes.
Whereas the report of the Central Bureau of Investigation referred to above indicates that the overall responsibility for successful implementation of the program rests with the principal secretary of the district council, and the day-to-day functioning of DRDA with supervision of headquarters and the blocks rests with the project director DRDA, who is the full-time officer of the program. This is one of the considerations. Now, next page, last but one paragraph. Whereas, after careful consideration of the relevant records furnished by the Central Bureau of Investigation, the views of the learned Advocate General Assam, and the assets and liabilities statements of Sri so-and-so, it has been found that the officer concerned served in the so-and-so block for a brief period of 2 months against his will, and the relevant records as are available do not show any criminal intent to earn wrongful gain on the part of Sri Tanmay putting so-and-so. Now, if your lordship comes to page 94, your lordship will find right from the beginning, the approach itself is different. The first paragraph, I am not troubling your lordship, the allegations are given. Second paragraph. Whereas Sri Moganjoy Thausen, ACS as BDO, and Program Officer Diong Valley Development Block was responsible for implementation of schemes including NREGA project strictly as per the NREGA guidelines to provide a basic employment guarantee in rural areas by guaranteeing 100 days employment in a financial year to a rural. The very approach is completely discriminating. Here they say that the entire responsibility rests with the principal secretary and the project director, who's a full-time employee. They completely forget that I was merely holding additional charge. My main charge was several miles away. I could not have done a day-to-day monitoring. That aspect is not even gone in. And in the entire order, your lordship will not find even a mention of the Advocate General's opinion, in my case. They ought to have considered and said that although Advocate General has said like this, in case of the Mr. So-and-so, we are taking a different view because of ABCD reason. But not simply to brush it aside and not even to mention it. Whereas that weighs heavily in the minds, in their minds, when it comes to the other two persons. On that, my lord, I am pleading violation of article. That you did not give a similar treatment when you were considered. But that is our case. And and this itself indicates one. I am only the program officer.
You are the program?
Program officer. The project director, there is a completely whole-time employee.
Those two were project director.
No, they were also a program officer.
Yes.
And to, in their case, they look into the assets and liability to see whether it is disproportionate. Why didn't they? Because I might have only because I'm assuming I have spent 5 years, but done so honestly, but there is some mischief during my tenure. If assets and liabilities which are not disproportionate is a relevant consideration, I might have been there as on additional charge for assuming 5 years. Only because I am there for a longer duration, I may still be honest officer. How can it not be a relevant consideration in my case, and it can be a relevant
These
consideration?
three are the same dates, you said, right?
Everything is same, madam. Everything is same.
Hang on.
Same officer.
I just checked that
Everything is.
because it was coming to my mind. Say, for example, if two courts are similar, they may have a
Different view.
not necessary to take into consideration 1, 2, 3 in all the cases, right?
Right.
Sometimes maybe two things that may have been said.
True.
Right.
Two different
But
officers.
I get what you are trying to
And
say
it-
home.
And if your lordship sees the
discrimination-
charge sheets also,
Which appears to be apparent.
apparent on the face of. And when there is a express discrimination, dissimilar treatment being given to similarly circumstanced people. Supreme Court has time and again said that it amounts to violation of 14. And if your lordship, I am not troubling your lordship all over again. If your lordship sees the language in the 3 charge sheets, word for word, except some facts and figures, Malad, everything is full stop, comma, everything is added.
Now, can this matter be, this is something coming in my mind that can it be disposed of in a direction, remanding it back to the authority to take a fresh consideration in the matter?
That is one of the ways of doing it. Your lordship may set it aside, and but your lordship will have to
Now,
perhaps record.
why I am saying so, because two things which you have successfully pressed before this court is number one, the reasons for not taking the AG opinion is discernible from the sanctioning order. When that same AG's opinion was taken as a factor for denying sanction to the other two
Others,
persons.
exactly.
Now, in your case, apparent from the sanctioning order that it has not, there is no whisper about the AG.
Absolutely.
Now, that apparently indicates the discrimination,
Absolutely.
correct? And second, there are many other things which you've already pointed out.
The
We
principal
get that
secretary is
picture.
responsible.
Correct. Correct, but
That is another.
see, this is one thing, and then, so whatever relevant considerations are there on the touchstone of discrimination, I'm talking.
Absolutely.
Otherwise, the apex court decisions are very clear.
Yes, yes.
Non-application of mine, not taking consideration of the relevant materials and all, the court will not go.
Well-
But here, there is a discrimination which is apparent.
Oh, which is
Now, that if this court under 226 notices,
Vale.
why should this court not set that right?
Absolutely. That is
Because
right.
this is
Okay.
the whole power of the 226
And that is
court.
what Dwarkanath
And nobody can
Prevent
take
that.
away this power
That
from this court.
that cannot be
If this
diluted.
court sees it. Right. On that I am saying.
Yes, absolutely. Ma'am.
Otherwise, Mr. Nath is right.
I in fact agree
This
with you.
court will not go into the aspect of prejudice and all
Yes,
this. These things
Certain-
in the trial court. So now keeping everything in mind, it appears that the allegations are serious.
Ma'am,
Right. Therefore, that perhaps balance both the sides.
that is what-
If the sanctioning authority takes,
your lordship will
to
strike this
account
down
the-
and let them take a fresh call. And your lordship will just indicate in the order that these are the considerations which have weight in case of the other.
that of course, while recording a submission and this, because of that only the matter has to
Yeah, absolutely.
has to go
absolutely.
back because apparent that the AG's report otherwise has not been taken into account, isn't it, Mr. Nag?
But if my lawyer seniors,
No, I'll get back to him, but on this,
I will not reply. But here lordship is not examining the sanction order.
correct,
That's
but
not a-
sanction
it's-
order, when I'm examining the sanction order,
Look.
the other grounds taken cannot be lose sight of, isn't it? Now, what the primary ground of attack of the sanctioning order is that they have been given a discriminatory treatment.
But,
Article 14 is there, is been violated, and they are demonstrating that by showing that the AG's opinion, which is in favor of them, though was considered in respect of the other two persons in a similar allegations, in his case, it has not even found a mention. That is admitted, isn't it? But Mr. Nath, isn't that an admitted position?
the order is not reflected.
Correct. Now, so you see, if that be so, why to go into the merit? Because then it will prejudice. Admittedly, the AG's opinion has not been taken note.
But whatever materials they have not, in fact, the AG's opinion is one of them. It was on the record and it was before the order. They have not mentioned, there is no mention in the order about the AG's opinion.
Mr. Nath, it is not about the mentioning. It is, you see, by relying that opinion, two persons have been denied.
Only
Now, when the same authority is granting by not relying the AG's opinion, do you not think it is a relevant thing to be pointed out in the sanctioning order as why the AG's opinion has been ignored?
But that is what the petitioner will put the question to the authority, sanctioning authority, why it was not considered in
In
my
the
case.
case of declining, that reason is there. But why in the case, because you see, Article 14 has come now. The moment you are accepting the AG, you have accepted the AG report and acted in respect of two other officers, in respect of the third officer, you are not even mentioning anything.
But
The order doesn't have to mention the reasons why you are granting the permission. You have mentioned the other reasons, but this is also one of the vital thing. The AG's opinion is in favor. Why is the AG's opinion ignored in case of the petitioner?
But reason is there in the order. The order itself is very clear.
Where? AG's opinion?
AG's opinion they have not mentioned.
Then,
Whatever is not there, I cannot put it.
exactly. See, that is why I am saying that if it goes back to the sanctioning authority, let him take care of the situation.
But please see, paragraph 16 of their petition, they have mentioned that here the section is under section 19. In paragraph 16, they have said that the honorable the trial court has on 11/7/2014 has framed the charge against him. The sanction after the sanction only, prosecution sanction only, the charge against them. Now that charge, framing of charge under section 123, 420, 468, 471, paragraph 16 of their petition. If lordship today interferes with the order on that ground, ultimately this will affect the charge order. Because without prosecution sanction is a prerequisite for the charge. Without the sanction orders, charge cannot be made.
That case is already pending,
It is
where the charge sheet is under challenge, right?
charge it, yes, charge is in front.
Correct, but that is under challenge.
It is not.
It's still pending.
It is pending. Since
So
2015.
if this goes, that becomes infraction.
But in fact, when the position is very clear, that the whether the AG's opinion was considered. or
Because
not,
you see, for some reason, I dispose it on merit by holding that the sanction order is wrong. And also everything will go,
everything.
isn't it?
And that is why.
But since that is the main crux of their argument, that is why I was asking whether it can be disposed of in that manner where it is sent back to the sanctioning authority.
But if I may,
Or if you want, you can think over, we can have this matter tomorrow listed again.
but if I may clarify, even the argument which has been made that whether the AG's opinion was considered or not, that is a question to be put to the sanctioning authority during the trial.
That
When
I have understood.
when the
That
sanctioning
you
order
have
will
made
be
it very clear that all these things can be put to the sanctioning authority at the time of trial, therefore no prejudice is caused.
Yes, the paragraph 20
But you see, Mr. Nath, the other thing that is troubling this court, suppose they have been discriminately treated, then why should they face the prosecution? Why should they face the trial? When other two persons, you have acted in a different manner. Now,
But the prosecution.
here, if those two persons were not there, then it would have been a different case. There was no difficulty in appreciating your argument.
But why?
But the fact that in respect of two other persons, you have accepted the AG's report. In the case of the petitioner, AG report is nowhere mentioned. What was the reason for not accepting the AG report?
That reason,
The AG's report has no value.
I'll not say that.
No, then what is the reason? You see, that is why I'm saying
But
that it has
that is
the order of sanctioning appears has not
the
mentioned anything of the AG report. What has happened to that?
Not happened.
Or you have the records? Let us see the records.
that I can.
You
that I can say.
produce the record. When can you produce the records?
Ultimately, that is the non-application of mine they have said.
Non-application
they are
of
bidding-
mind is a very wide term.
That is
It would
what they are
depend on the
bidding now.
context of each case.
Paragraph-
You see, Mr. Nath, here their main ground of attempt is Article 14, discriminatory
But
treatment.
Article
Now,
14
this court has to give a finding to that argument. Suppose this court, on the face of it, it appears that the AG's report is not taken into account.
But all these things.
Now,
all
after
these things
seeing
are
this,
mentioned.
should this court close its eyes under 226?
No.
Only because they will get a chance and opportunity in the trial to question the sanctioning authority.
Well, the argument of alternative remedy.
That I am not. I'm not on that.
Got
That is a different analogy. I'm not accepting
Got
that. position.
Paragraph.
I'm not on all that
No.
about alternative
Valid-
remedy.
it is-
Whatever has been argued on that, I am not taking that. But discrimination, if this court finds, then certainly yes.
The lordship will consider one thing, Lord. The prosecution sanctioning authority, he has exercised his power under section 19 of the Act. It's a protection given to a government employee, and while passing the order, he has considered the materials available before him.
Uh,
If some material,
Upon the option.
if some material he has not considered, and he has to be asked, why you have not considered this?
That
That-
is that I'm on. I said I am with you on that also.
Got it.
There is no difficulty.
Madam.
But factually, because of the AG's opinion, there is a little difficulty. Otherwise, I'm with you. I'm definitely with you on that.
So, the
In fact, Mr. Chaudhary has also fairly said that if relevant consideration not taken into account, that can be relegated to the can be taken care of at the trial.
So they have said that without any justified reason, mechanically the organization, that is not the case. Ultimately.
Mechanically. You see, you are putting that word mechanical.
No, Malak,
They are saying this
this is
article.
paragraph 20 of their petition.
There may be several, but what has been argued before this court is about discrimination,
But-
not a mechanical approach.
Malak, ultimately the mechanical approach or the discrimination, that is.
Different. They both are very different, Mr. Nath.
Mechanically, without any justified reason, they have said.
Mechanical means no application of mind.
That is non-application of mind, and non-application of mind is well covered there.
There is no difficulty in that. Yes, which is the provision?
Section 19 of the PCA. Previous sanction necessary for prosecution.
19.
1.
Yes.
So section 19 is previous sanction necessary for prosecution. No court shall take cognizance of an offence. 1. No court shall take cognizance of an offence punishable under section 7, 11, 13, and 15, alleged to have been committed by a public servant, except with the previous sanction, save as otherwise provided in this range. Then, so my submission is not the prosecution sanctioning authority. He has exercised his power under this section 19, following section 19, he has given the sanction. And the requisitioning authority, that is the CBI here, the entire materials is in place. Well, that is why in the second case, which I have placed reliance of 2015 case, there, Lordship has seen that the file moved from this to that. So many authorities give their opinion that positive, negative, something, many opinions may be there. But
And the final authority is the sanctioning authority, the competent authority who has the authority under this provision.
There is no quarrel
Yes.
to that proposition,
And
but you see, in this case, that particular fact is creating difficulty.
But-
Same date, same officer, same AG's opinion, where the AG says these three officers not to be prosecuted,
But in fact-
sanction not to be given.
In fact, the
Now, you, on the same day, in respect of the other two, you accepted the AG opinion. In respect of the petitioner, we don't know what you did about the AG, or how you dealt with the AG opinion.
they have not met. That I cannot follow.
See,
Because
I am
they
having a
have not met.
difficulty only there, Mr. Nat. Nowhere else. Otherwise, there was no difficulty. Only there. And it's the same day, same officer. It's not that this is done by somebody else.
Yes,
The same gentleman,
same officer. Same officer has
same day also.
date of the order is.
And same AG of opinion, not that they are different on the opinion.
So one opinion, in respect of all the officers.
Correct.
Because
That is why I'm saying same opinion.
at one level, in fact, the opinion indicates that at one level, file was moved that sanction will not be given to the officers. At that stage, and there was some delay that at that stage, the opinion was taken. The authority, after considering the materials, they have decided not to give to some.
Individually, I see, there is also not difficulty in understanding that of course you will have to individually consider each case,
So-
correct? See, there is no difficulty there. But the moment you don't say a word
But,
as why you have not accepted that AG report,
uh,
that creates a doubt. That creates a doubt that something is wrong, isn't it? Why is it that the AG report was not taken into account in case of the petitioner?
Well, it is not mentioned, but I cannot, I have some limitation because it is not. mentioned.
You want to produce the records?
If logic directs, I have to, I'll produce, but my respective submission is. But little difference here and there will not make any change in the.
That is true, but here that vital thing that common factor changes the whole entire gamut of the case.
Because the AG's opinion is there. But the reason, if the order is not, there is no reason in the order, then logic, the consequence would have been different. But little bit of difference, of factual difference here and there, will not make the vast difference. That is what my.
Let us see that sanctioning order again, 94,
Page 90.
94.
From the order, logic will see whether he has applied his mind to the materials available before him. But, whereas it is at page 94 and
Yes, second paragraph.
second one, whether she so and so as video and program officer so and so block was responsible for proper implementation of schemes, including the NREGA projects strictly as per NREGA guidelines to provide a basic employment guarantee in rural areas by guaranteeing 100 days employment in a financial year to a rural household, and whereas it has been alleged that funds under NREGA were received by the so and so block from the project director, District Rural Development Agency. Along during the year 2006-07, the block received a sum of 16 lakhs 96,000 16 crore 96 lakhs 43,510 on the NREGA and SRY scheme, and the block spent a sum of rupees 12 crore 58 lakhs 92,973 under the above scheme. And whereas it is further alleged that Sri so and so the then junior engineer and Sri so and so the then junior engineer posted in so and so block entered into criminal conspiracy with Sri so and so the petitioner of so and so block, and in pursuance of the said conspiracy preferred false master roll cash voucher of rupees 25 lakhs 44,183 during execution of different works in different villages places under the block, which were passed for payment by said accused Sri so and so the then video Doyangvili development block, whereas there was no implementation of such work as claimed by the voucher bills. The said Sri so and so the then executive engineer and Sri so and so the then executive engineer of the block falsely made entry in the measurement book of the work shown executed, which were countersigned by the accused Sri so and so the then video of so and so. Payments were shown
made to the beneficiaries as reflected in the cash book of the clock, whereas no such execution of work was done as confirmed during field visit. The supplier firms who were shown to have supplied materials were not found to have existed, and whereas the aforesaid acts of said accused public servants is so and so the damn video constitutes offenses punishable under section 120B, 409, 420, 468, 471 IPC, and section 13(2), wherewith 13(1)(c) and (d) of the PC Act 1988. And whereas the Governor of Assam, after fully and carefully examining the materials before it in regard to the said allegation of the circumstances of the case, considers that the said Sri so and so the damn video of so and so should be prosecuted in a court of law for the offences mentioned above. So there is application of mind. He has applied his mind to the materials placed before him in response to the allegations, whatever has been alleged and whatever materials have been placed before. So accordingly, this order was issued. And accordingly, he said that now therefore the government of Assam doth hereby accord section under section 19(1)(b) of the Prevention of Corruption Act 1988 for prosecution of said so and so the then block development officer for the said offences committed by him and any other offences punishable under any other provisions of law in respect of the fact and circumstances mentioned above, and for taking cognizance of the said offences by the court of competent jurisdiction. After one of this, the court has taken cognizance and proceeded in the matter. It is a different fact that they have again challenged the further proceeding has been stayed since 2015. The proceeding is stayed, and here Lordship, while examining the prosecution sanction order, Lordship will see whether materials were there or not and whether the authority has applied his mind. But in fact, my respectful submission already I have placed. I will not repeat that because the position is very clear. So ultimately, whatever ground the petitioner urges, but unreasonable.
All right, that I've understood. Mr. Chaudhary, sorry, I had stopped you in the middle. You can complete.
No, I have completed, madam. The only point is that exactly the same
So for
situation.
that judicial review, you are citing 66,
Madam,
99, 95(4) is what?
95(4) is also on the same point. Let me quickly place it. There are
Yeah.
two short paragraphs.
Yes.
95(4) is it? Two short paragraphs,
12 and 13.
12 and 13. The reason is very simple, madam. In fact, to straight away reply, what my learned friend was now trying to impress upon your lordship is that even this ground I can urge it before the trial court. Let us not take a trial court to the level of a 226 court. 226 is an exclusive power, extraordinary power conferred. Your lordships intervene the moment your lordship finds there is a violation of part 3 of the Constitution. And the fundamental rights, as soon as they stand violated, your lordships intervene. That power, how can a trial court exercise? 14 is not, that cannot be delegated to a trial court. It can look into non-application of mine. It can look into whether any prejudice has been caused. But when the moment your lordship is satisfied that there is a violation of part 3 of the Constitution, your lordship intervene under 220. So that is a arguments which would amount to stretching it a little too far. Para 12. It is therefore, has my lord comment.
Yes.
It is therefore necessary to deal with this question in the instant case. We may in this context put out that a distinction has to be made between judicial review and justiciability of a particular action. In a written constitution, the powers of the various organs of the state are limited by the provisions of the Constitution. The extent of those limitations on the powers has to be determined on an interpretation of the relevant provisions of the Constitution. Since the task of interpreting the provisions of the Constitution is entrusted to the judiciary, it is vested with the power to test the validity of an action of every authority functioning under the Constitution on the touchstone of the Constitution in order to ensure that the authority exercising the power conferred by the Constitution does not transgress the limitations placed by the Constitution on exercise of that power. This power of judicial review is therefore implicit in a written constitution, and unless expressly excluded by a provision of the Constitution, the power of judicial review is available in respect of exercise of powers under any of the provisions of the Constitution. So there has to be an express prohibition. Only then the argument that has been advanced. And if your lordship now comes to para 13, it's the longest paragraph, the parameter. A judgment of Justice P.N. Bhagavati is quoted. If that first quoted portion in paragraph 13, if your lordship sees, what would be
Yes,
the quoted portion, madam?
yes.
If the satisfaction is mala fide or is based on wholly extraneous or irrelevant grounds, the court would have jurisdiction to examine it, because in that case, there would be no satisfaction of the precedent in regard to the matter on which he is required to be satisfied. So extraneous or irrelevant ground. Here is, rather the opposite, a very, very relevant and germane consideration has fallen from your lord. The Advocate General's opinion, where the Advocate General said that they need not be proceeded against. That learned Advocate General's opinion is in totality accepted in case of 2. It is ignored, not rejected. It is ignored in my case. Would that not amount to violation of article? And if it amounts to violation of 14, would your lordships not step in? That's the question. It's a very, very intricate, fine situation that has arisen in this case.
Mr. Chaudhary, that sanctioning order need not be a detailed order, because
They have to record reasons, because it has to be the power under 19 is conferred on the sanctioning authority to protect against
any
malicious.
decision on that point, any authority on that point. Because why I'm putting this question to you is because the subsequent 2 decisions which the Nath has shown is that even if decision is non-application of mine, but even that can go into the trial court. Now, and that section 19 only says cannot be proceeded without previous section. But previous at the time of giving sanctioning, whether the fact that it is mentioned that considered or everything, is it sufficient, or everything has to be
Everything need not be, but
Yeah.
your lordship is aware of the law, my lord. It is only in case of executive actions that reasons need not be recorded. Here is a statutory function being exercised under section 19 of the PC Act.
reasons is not in details. They have stated that these are the allegations, this is what has happened, and considering facts and circumstances, material, giving sanction. Now, 2 situations can be visualized at this moment, that there are certain materials.
Yes.
The allegations are there, the materials are there for going ahead, irrespective of the AG's opinion. What they did with the AG's opinion, of course, is not discernible, admittedly is not discernible. Now, just because that is not discernible, can it be said that the entire sanction order is banned? Because some materials.
I appreciate what has fallen from your lord. To immediately respond to that.
And that also because in respect of another 2 persons, those similar allegations, but in respect of a different transaction.
But what has fallen from your lordship, I appreciate. What your lordship is essentially saying is that, assuming there are materials which could lead to 10 different reasons, they may record some, they may not record some. And assuming I would have been an independent standalone case, and one of the materials placed would have been the Advocate General's opinion, and then it is available on the records, but it is not reflected in the order. That would be a different situation altogether. But here is a situation where the same Advocate General's opinion was accepted to be a relevant consideration, but ignored in mind. That is how discrimination in Article 14 comes in. If your lordship goes through all those judgments on similar treatment to similarly circumstanced people, the principle is that if you are applying one yardstick for Mr. A, Mr. B is identically placed, you are not applying that yardstick to Mr. B. That would amount to unequal treatment to a equally circumstanced person, and that would lead to violation of Article. So that is exactly the case before your Lordship. Assuming, had I been a standalone case, AG's opinion there in the file, your Lordship can presume that this must have weighed in the mind. They have considered. But here, it's not a standalone case. There are two more people. And there you have accepted. So therefore, my lord, in my respectful submission, it straightaway militates against Article 14. And
Pick and
not just
choose.
that, your lordship
Because
can
it's
see,
like a pick and choose.
pick and choose. Not just the Advocate General's opinion, the other aspect, my lord. Just to corner
Against
me.
will. You also continued against your will.
No, no. In my case, they completely ignore that the principal secretary is the main person responsible. The project director is the main person responsible.
Which they had considered in that.
And they say that they cannot be held responsible because the main person is the principal secretary. And the project director. And they go a step further. They record a contrary finding that the entire responsibility is mine. How can you apply two different yardsticks for two different people? Therefore, 14.
But that indicates biasness of the sanctioning authority.
And bias, as your lordship is aware, bias is one small component. That and bias, as your lordship is aware of all those judgments, that not only actual bias, even the inclination to be biased itself is also open. But bias is only a very small component of Article 14. Bias leading to actual discrimination is the point here.
This you are distinguishing that paragraph of the apex.
Well, and in fact, that is why in the second judgment, that 2015 judgment, the Supreme Court records that a totality of the facts were taken into consideration. Now let us take a look at it from the opposite side. If those totality of the facts were not taken into consideration, Supreme Court had intervened, who would have intervened? So this is expressly recorded in paragraph 20.
Mr. Agarwala, which matter are you waiting for? I don't think there'll be much time for any other hearing matter. Indicating. Yes. Yes.
So therefore, my lord, and on those I am not repeating, my lord, those two, that equal treatment and Article 14, those two citations I have already given, the case laws are already there. I am not repeating, my lord. Your lordship may just check whether they are there already, or your lordship has noted it. It's of course reflected in my written
Equal treatment is 2002 8 SSC
Yes,
and 2005 13 SSC.
13.
Just one second.
Those two are on the issue of equal treatment to similarly placed people.
2003 Surya Dev is of course 226 para 29 you are relying,
Yes.
right?
Yes.
Then equal treatment
2002, volume 8.
there's so many case laws.
I have given, my lord, a total of
2005 13 I have got.
2005, 13
That
and
is
2002,
11.
volume 8.
This is on equal treatment. This is on equal treatment. Then 2002,
2002, volume 8.
this one is not available. 2002 8 is not there. You have an extra copy?
We'll give a print off.
2002 8, just give that. Then 2001, what is that for?
That is for when it amounts to violation of Article 14, witness is reasonableness. 2001, volume 2, SCC 386, para 67. When witness is this
Read para 67.
2001, 2 SCC 386.
This is on, no, not on.
This is that witness is this one. How it amounts to violation of 14. para 67.
Yeah.
But where an administrative action is challenged as arbitrary under Article 14 on the basis of roya-part, as in cases where punishments in disciplinary cases are challenged, the question will be whether the administrative order is rational or reasonable, and the test there is the Wednesbury test. The courts would then be confined only to a secondary role and will only have to see whether the administrator has done well in his primary role, whether he has acted illegally or has omitted relevant factors from consideration, or has taken irrelevant factors into consideration, or whether his view is one which no reasonable person could have taken. If his action does not satisfy these rules, it is to be treated as arbitrary. And this is what is the Wednesbury test, and it would amount to violation of 14. Last towards the later part, that is what. And all the case laws pertaining to the Wednesbury principle are relied on.
This is in context of a disciplinary proceeding. ma'am.
Following Royappa. And the other one is the famous Malad. I'm not troubling your lordship. This is Ramanna. 1979 3SCC 489.
This is not there in your, in this list of your submission.
In this one, I have not given.
All right. One is sufficient.
So therefore, my lord, in my respectful submission, this is a
Who have submitted these decisions? Dinesh Kumar, 2012.
that is those two.
Dinesh Kumar, I have-
Dinesh
Oh,
Kumar
this-
and the other one is 2015 volume 16.
All right. So I think that time what was available was the Supreme today. I had called for the SSC printer. Because SSC is easier.
Easier.
Manan, I have indicated the paragraph.
To the other people.
But,
Okay, actually get it. And PL Tatwal, 2014-11.
14-11, I have not.
Even I have not given. This I think is from some other case.
Is also relating the corrupt PC Act only, maybe grant of sanction. Act 12. You have given.
This must be from the earlier proceedings.
The grant of sanction is only an administrative function. It is intended to protect public servants against frivolous and vexatious litigation. It also ensures that a dishonest officer is brought before law and is tried in accordance with law. Thus, it is a serious exercise of power by the competent authority. It has to be apprised of all the relevant materials, and on such material, the authority has to take a conscious decision. It supports your contention as to whether the facts would reveal the commission of an offense under the relevant provision. No doubt an elaborate discussion in that regard in the order is not necessary, but decision-making on relevant materials should be reflected in the order, and if not, it should be capable of proof before the court. This is 2 judges bench, 2014. Maybe it was given on earlier
No,
occasion.
no, no.
And there is one more, Ashok Shankara Chavan versus Vidyasagar Rao. Again, sanction. These are on sanctioning powers.
These must be from, because I have stepped in on at the 11th hour.
Anyway, these two are giving me some idea about the sanctioning power, which I was thinking of
But-
Yes,
looking into.
in fact, the sanctioning authority, he is the prime witness in the,
That you have said, there is no difficulty.
in the sanction order, one of this judgment indicates that how he has given the sanction, he has to answer that.
Only thing, arguments, I'm going to say it's closed, but I'm posting it on Friday. Can you have the records?
One of the,
On Thursday,
Friday,
or on reopening.
I'll try to get one of the Thursdays too short.
And on the reopening,
On the reopening.
On the reopening,
we
because
will-
Friday I may not be.
arguments have been,
22nd.
both sides have concluded their argument and have also submitted their written arguments, which is kept on record. The relevance, the records, being relevant, let the same be made available before this court on the next date of listing. List by Mr. D. Nath, Learned Senior Counsel for this, Learned Senior Government Counsel for the State Respondent. And before you write, heard by Chaudhary, Senior Counsel, assisted by S. Chakraborty, this side, D. Nath, Senior Government Counsel for the state. And list on video view.
Lordship may keep it on 22nd.
So as part. Only for the purpose of if you give me the record, then I will close it on that day. If you.
Deep level.
Blinders clip to hobo negi. এটা ডাঙৰ দিয়ক আৰু এটা সৰু দিয়ক। আৰু এইটো তেওঁলোকৰ পিছদিনা দি দিয়ক। You get me the record, then we can close it. You know? Thank you. Then appears for the petitioner on call, a list after 2 weeks on a date to be fixed by the registry. এইটো সেই ৰাতিপুৱা মেনশ্যন কৰিছিল যে as prayed for with mention in item number 19, 21, if no, you first, Pasha, this order is a common order for 19, 20, 21, 22. Now you write in learned counsels appearing in criminal revision petition 278/2012, criminal revision petition 162/2012, and criminal revision petition 163/2012, 6 accommodation for the 6 accommodation in the matter. Prayer is allowed, list on such and such day.
26.
And there you mentioned one thing, none appears for the appellant in item in criminal appeal 54/2012. Same, huh? Because
I'm appearing for respondent, petitioner sides.
this matter came on the other day.
Yes, your lordship.
That day the petitioner side was appearing or not?
Yes.
Then maybe they have thought
I think
because of the it is already fag end of the probably they didn't expect it
Yeah.
to reach.
It might be outside also.
No problem. In item number 26, you say none appears for the petitioner on call. MSMD Borwa, Learned Legal Aid Counsel, is present for the responding. List after vacation for the video on such and such date. On
8 May.
is it okay? 8 May?
Much of.
Mr. Counsel, Mr. Das, please give that citation. There is one photocopy which you have to give.